Hey guys. I'm really excited to be talking about this case. I've been deep diving into it for a week now, and it's been a lot to take in. But this is going to be a wrongful conviction story. This man has been wrongfully incarcerated for 17 years. It's not a subject that I think weighs lightly on anybody who cares about due process and the justice system having integrity. So we're going to do a deep docket dive on this case. Before we get too far into it, I want to make sure that I'm shouting out something that I think everyone should check out. This is a podcast by Stephanie Tinsley. She started this podcast after wanting to dive into a case that something just wasn't right about. And she shares that story in her podcast. You'll hear more about why she was looking for a case like this and how she ended up working with Andrew Hayes' current attorney to start looking at this case file. The reason this is so important is not just because it's a great effort by Stephanie Tinsley. Part of the work that she did throughout this investigation has now led to the Shelby County District Attorney, Steve Mulroy, to say, you know what? Andrew Hayes is actually innocent. And the real perpetrator, at least one of them, has gotten away with this. So in the last couple of weeks, so all in 2026 here, Steve Mulroy announced charges against Sarah Lucas Rydell. She's in Oklahoma, so I think they're still trying to extradite her, but she has been arrested. And he has declared Andrew Hayes innocent. Now, this podcast, if you go check it out, it's going to give you the deep dive on the story of the case. Stephanie includes everything from like case evidence, what actually happened, details from interviews and interrogations, interviews like contemporaneous interviews that she did in the last year and change with the original jurors who were sequestered. And a lot of them had the attitude of, well, I want to go home. One of them even said she didn't want to miss her birthday party. All of that stuff. There's an incredible depth of information in this podcast, and I'm super excited that, I see Law Kong Express in here, Trakeisha's in here. Where's Autry's fake accent? A lot of you have already told me, or I've seen you in the comments over there saying you're checking out this podcast, and I've heard nothing but great feedback from it. So if you have not checked it out, it is linked in the description. Again, it's called Everything They Missed. They only have 344 subscribers. It's an incredible podcast that, again, has led to at least the out loud declaration of innocence from a district attorney for Andrew Hayes. We're going to get into where the case itself sits right now, but it looks promising, and I'm very optimistic. So before we get into, I'm going to stop and say hey to the chat in a minute, but I want to go through, I think it was the beginning of last week. So I'm always looking for updates in cases with wrongful convictions, Court of Appeals decisions, anything where, hey, there might be a big question here. And one of the stories I came across, I believe this was the exact article that put me down this rabbit hole. So I want you guys to see what got me started in the rabbit hole. So last week I saw this article, New Evidence Leads to New Suspect in 2007 Memphis Homicide, District Attorney says. So Shelby County District Attorney, that might be a familiar locality if you guys followed all of the Zachary Adams post-conviction relief stuff. But the district attorney here said that the wrong person has been imprisoned for a Memphis murder nearly 20 years ago, and a new suspect has been arrested in Oklahoma. Steve Mulroy said his office was righting a wrong in the murder of Danny Harris, who was beaten to death in his apartment in 2007. His decomposing body was found months later. Andrew Hayes was convicted in 2010 of first-degree murder and aggravated robbery and was sentenced to life in prison. A woman named Tammy Vance, who's here on the left side, also pleaded guilty in the case and is serving a life sentence. So Tammy Vance has now passed away. About 15 years later, Mulroy, and I don't know why, I think this article missed it, but it's something that I heard while doing this deep dive. About 15 years later, Mulroy said new evidence came to light, resulting in an investigation by his office's Justice Review Unit with assistance from the Tennessee Innocence Project. Our investigation has concluded that Andrew Hayes was wrongfully convicted of murder, Mulroy said. And I think this is a huge, huge deal, because part of the way I've structured how we're going to do this stream is to illustrate the timeline for the last 17 years while Andrew Hayes has been wrongfully incarcerated, of the appeals efforts, the post-conviction relief efforts, and how just one after the other denied. So it's critical, in my opinion here, that Steve Mulroy is saying, you know what? Andrew Hayes is innocent. Lawyers have since filed another petition to vacate Hayes' sentence, and Mulroy said his office would not oppose the petition. So, additionally, Mulroy said the investigation led them to another suspect, Sarah Lucas Rydell, who is Vance's daughter, so Tammy's daughter. This is Tammy up here. And who Mulroy says facilitated the murder. Charges have been filed against Rydell, and she's been placed under arrest in Oklahoma, pending extradition to Shelby County. So, when I was reading this last week, I'm like, what? Like, dang, not only do they think this guy is innocent, but they're making the effort to go and charge and extradite somebody who's out of state. So I want to see what's going on, because I think it takes a lot, for better or for worse, probably for worse, for a district attorney to get to that point. So we've got here that Mulroy and Hayes had confessed, Mulroy said Hayes had confessed in a 27-hour interrogation. 27 hours. And of course, we're going to talk about it here, but I found out through the Everything They Missed podcast that only a small portion of that 27-hour interrogation was recorded. What parts do you guys think were recorded? The end, where someone's finally giving someone the information they want to hear after asking, what do you want me to tell you? Or do you think the parts leading up to that were recorded? Big hint, it's the latter. They only record the parts that seem helpful. They don't record the initial long parts where we have Andrew Hayes maintaining his innocence. So, but Mulroy believes it was a false confession. He says Hayes was intellectually disabled, and some details in his confession didn't match the evidence. Mulroy said that if the wrong person is behind bars, then the right person is out there, and we need to hold them accountable. Executive Director Jason Gichner. So this is the attorney we're going to watch the appeal oral argument. It's going to be Jason Gichner arguing. Of course, we're going to find out that that appeal was denied, but I still think it's great to watch the oral arguments. And Jason Gichner is the one who, when Stephanie Tinsley was like, give me a case, like, what case should I look at? Jason Gichner was like, well, I have this one, but I'm nervous. And Stephanie Tinsley describes in one of her podcast episodes, Gichner describing that sometimes there's an apprehension of talking about an effort, an Innocence Project, a Tennessee Innocence Project, or any of, initiatives by other state Innocence Project projects. There can be some kind of like backlash and issues where if you talk about a case that you're looking at and what was so wrong with it, it might go the wrong way. And what that made me think of was Amy Wyrick over in the Zach Adams case, The Power of the Podcast, and how there's such a type of attitude from the state when they find out that somebody's telling them that, hey, you might have been wrong about something, maybe we should take another look. And I'm really glad that Steve Mulroy here didn't put up that guard. So, factual lie. Yeah, we're going to get to that too. Factual lie says, what are the odds of the name Bobo being involved? And not related. I looked, but we're going to cover that in a deeper case summary here in just a minute. But I couldn't believe that either. I was like, here we go. So, Gichner says he released a statement Thursday afternoon in response to the wrongful conviction of Hayes. So this is from his attorney, his current attorney. Andrew Hayes has spent more than 18 years locked up for a murder he did not commit. He's locked up today, an innocent man, serving a life sentence for a crime committed by somebody else, he stated. Andrew has a family that loves him. He has a son that needs him. The Tennessee Innocence Project will not stop fighting until Andrew walks out of prison and comes back home to his family in Memphis. So I would love to be able to do an update video like sooner rather than later to just be like, hey guys, guess who got released today? So I will be keeping my eyes peeled for that. Now, I like this little last bit in this article here. And this is linked in the description if you want to read the whole thing. The Shelby County Justice Review Unit has closed 533 cases. Only 5 of those convictions were overturned after a hearing. The unit has 110 cases pending. And I would think that this would be 6, but it wouldn't be due to a hearing necessarily. So again, it seems like Mulroy just heard what was going on with this investigation and was like, oh, this doesn't seem right. So, but we still have to wait for the final decision. Now, what I did for this case is I'm using an app that I've used for work to help organize materials for clients and create training manuals called Gamma. And what I like about Gamma is I can take something that I've typed up elsewhere, like the raw words, and it'll make it like a pretty presentation. And I'm like, well, let me do this for some of the cases that we talk about. That way we have something on screen and I'm not just blurting out dates, names, and trying to find a way to display to you guys what I'm talking about. Well, I realize a really cool feature of Gamma is I can constrain, it uses AI tools, but I can tell it to preserve the words I'm feeding it. So it won't go off too much into La La Land and like start hallucinating random things. It'll take my words and just the AI will do formatting work. And then I can publish it as a page. So there is a link to it's called My Deep Dive, and I put in parentheses that it's Gamma. If you click that, anytime I update this, that same link in the description right now should reflect the updates. So you'll get whatever I have in there currently. And I thought this was a nicer way to try to digest everything that we're going to talk about in this stream. So let me know what you think about this type of feature. If there's a different way that you think I should organize or present, like do you guys prefer little embeds like this, or would you rather it just be a blue hyperlink? Let me know. So of course we've got the background here, 17 years, now 18, Andrew Hayes' wrongful conviction story. We know about DA Steve Mulroy, and we're going to look at his press conference in a second. But here's where I really organized the timeline and a case detail deep dive. So if you want to jump to a playlist that I put together with a bunch of stuff, let me open that, show you guys what it looks like. Yep, I know I'm leaving Gamma. It's okay. And I'll continue to update this. This is, of course, is hosted over on YouTube, but you could see here's the oral arguments. Here is the podcast in order. So if you want to just use this as a way to go episode by episode through the Everything They Missed podcast, you can do that. Here's the press conference we're going to watch in a second. And then here's a few news articles. And unlike the Zachary Adams case, there is no like trial feed online for this. I couldn't find any videos talking about the filing of appeal, like so-and-so Andrew Hayes is appealing his conviction back in 2012 or 2017. I really didn't find the depth of coverage. This was not on the radar the same way that the Holly Bobo case was. But this is what I'd found, and it's there, and anything I see that's relevant, I'll pop in here as well. But if you guys want to check out any of this content, do your own deep dive, that link is in the description in this Gamma. And of course, the Everything They Missed podcast. So now let's get into a top level, deeper dive summary of this case. This is really my summary, and it's leaving out a lot of the key details from the Everything They Missed podcast because Stephanie's presentation is great. So again, it takes about 3 hours if you watch it on regular speed to get through episodes 1 through 6. She speaks slow, like podcast style. So if you're open to listening to things faster, I think it's the type of thing you can easily listen on 1.5 or 2 times speed. So you could get through her whole podcast and learn a ton in 3 hours or less, probably faster than 3 hours. But here's just some notes that stood out to me that I threw in here so we can get a deeper grasp. So we've got Danny Harris as the victim. Danny Harris was a 55-year-old retiree living in Cordova, which is a suburb around Memphis. He was found murdered in his apartment roughly 2 months after he died. Now, we find we're going to hear, if you listen to the Everything They Miss podcast, that they use pacemaker data to determine the time of the attack and ultimately when Danny Harris passed away. But when he was found, he was like horribly, horribly decomposed on his bed in his bedroom. When they started looking into the case, they had found like a note card or a business card, a contact card in his home that tied back to a police officer. And they're like, hey, do you know this guy? And he's like, well, that's my dad. So when they started looking at the case, the people closest to him, that they saw the names that were coming up in his phone records, were tied to a web of prostitution, stolen property, there's ATM withdrawals, there's pawn shops, they're selling items that were taken from Danny Harris. And when they're asking them about these details, the story doesn't seem to stay consistent. Key names, they have Tammy Vance, who shows up right away. She was looked at, she was considered to be Danny's on and off again girlfriend. Seems like she was tricking, if you ask me. They met on Telemates, a hotline for like the dating company Megamates. So, you know, we're getting all the Easter eggs that we've seen from other cases we've been talking about recently. When Danny's body is discovered, Tammy had been driving his truck after he passes away. Tammy's just driving around in his vehicle, no big deal, whoop-de-doo. She's cashing in some of his retirement checks. There's a TV that was stolen, and part of the head scratcher for investigators was like, well, we don't think Tammy Vance removed a TV by herself. So we think that she would have had to have been doing that with somebody else. What's going on here? So that sets off some curiosity. And then other items end up going missing and end up being pawned. So Sarah Lucas Rydell. So different names here, but it is Tammy Vance's daughter. She's named early, she's interviewed, she denies involvement, but it's known that she's the one that's going and pawning items. And she's like, well, my mom told me to do this. So, yeah, maybe I did these things. She'll admit to doing these things, but she says, somebody else just told me to go pawn this. I don't know what's going on. And investigators thought that was enough. They were like, okay. Now we're going to talk about Wayne. And this is what Factual Lie was mentioning a little bit earlier. So why is Andrew Hayes on the map? Well, Andrew's middle name is Wayne, and some people used to just call him Wayne instead of Andrew. Detectives were looking for somebody named Wayne. They're like, who's this guy Wayne? Because Tammy Vance, again, I don't have her picture up. I should have put it in here. But Tammy's like, well, there's this guy, Wayne Bobo. And don't worry, guys, I've already looked. No relation to Holly Bobo. Totally different family. Coincidentally, same last name. And Tammy claims that a key to Danny's apartment went missing from the key ring right after Wayne had access to the truck keys. So there's this name, Wayne. So the case, they're looking for a Wayne. And they're like, oh, well, Andrew's middle name is Wayne. Let's talk to him. So he had been around Tammy, he'd been around Sarah. And after he gives a ride to some family members, or he goes to pick up some family members from the police department, they're like, hey, can we talk to you real quick? And then suddenly we have a 27-hour interrogation. So this is how the case starts hinging on a confession. Andrew ends up giving up a quote-unquote confession after a marathon interrogation that was not fully recorded. The details of his confession don't match basic facts of the case. So there's issues with how he describes the apartment layout, what the injuries aren't matching up. You find out ultimately that Sarah, I guess the real story is Sarah hits Danny Harris with a hammer in the back of the head. And Tammy's like, oh my God, what did you just do? Then they panic and do whatever for the next several months. And Tammy will ultimately take the fall for her daughter. But Andrew gives details about this murder that don't match like a blunt force impact injury to Danny Harris's head. But the investigators don't care that his confession doesn't line up with the forensics, what actually happened. And then the timeline of when Danny has been dead doesn't match up either. Again, in the case file, you can look at the pacemaker data. And Andrew Hayes' story, his confession, doesn't match with what's known from that pacemaker data. There's other major red flags. What else is new? There's no physical evidence tying Andrew to the murder. No physical evidence. Again, it's a confession case. The confession includes details that don't line up, as we just talked about. He describes an upstairs apartment that does not exist. And this reminded me so much of Dylan Adams' confession in the Zachary Adams case, the Holly Bobo investigation. Dylan Adams' intellectual disability is pressed by Brent Booth and Jeff Jackson in this interview/interrogation, which over the weekend, the Trial and Error podcast uploaded the full thing. It's like 4 hours long. So if you haven't heard that, go check that out. I don't know when, but at some point, I'm going to listen to the whole thing and probably do a video looking at any key points that I hear that we didn't get to hear during the post-conviction relief hearings. So I was like, oh my gosh, this is similar, because Dylan Adams in that confession is talking about a basement at a property that had no basement. And Jeff and Brent are just like, oh, well, tell us something different and let's line it up. So I was like, oh my gosh, this is so similar. This is so similar. We have the issue of phone records and location data. There's more information that they could have looked at and didn't look at. Things that the jury did not get to hear. And I'm going to play a little clip of a juror in a few seconds. Well, we heard he wasn't there, but then we don't know what happened, and then we just convict him because we guessed that he was there. Well, there's all sorts of phone records and location data that show, Andrew Hayes was in a different place than what would have made sense for the theory presented at trial, and that the theory that investigators started formulating after some time. There's also phone records and location data that were ignored that show Tammy and Sarah end up taking this trip to Arkansas to go get an ID card. And the story is supposed to be that when they come back, Tammy and Danny Harris get into some incident. And Sarah's concerned that Danny hits Tammy and isn't treating Tammy right. And that's ultimately now the standing theory of why Sarah decides to go and hit him with a hammer. Well, Tammy ends up saying, and Sarah corroborates, well, after this trip to go get a new ID, they dropped me off. Sarah, I get dropped off at home, and Tammy goes back to Danny's. Sarah, was never there. But the phone records and location data do not show a trip to the residence or any side stop where Sarah would have been dropped off on the way back from their trip on the way back to Danny Harris's house. And they just ignored that data at the trial. So, crazy. There's also data of Danny's ATM card being used after he's already dead. Just over and over, they're using his ATM card. They don't really look into it, though. And then there's fingerprints from a checkbook that eliminate early suspects that they kept looking at anyway. And this is really just the short of it, you guys. If you listen to that podcast, there's so much more detail. Like, it's crazy. Couple notes on my favorite what moments. These aren't even the hottest, spiciest what moments. But here's a few. So Tammy and Sarah have a recorded jail call where Tammy, who's mom, remember Tammy's the mom, keeps saying, and this is after they have a preliminary interviews with the police. So they're catching up after Sarah has now spoken to the police. And Tammy says more than once to Sarah, oh, you're corroborating what I said to the police. The word corroborated is used in this recorded jail call. And Stephanie Tinsley was like, huh? Interesting. And this is one of the first things that made Stephanie Tinsley like, something's not right here. All right, then this 27-hour interrogation that we've already talked about. I don't think I need to go into detail about why that seems problematic, even for someone that might not have an intellectual or learning disability. 27-hour interrogation. Partially recorded. Even though Tammy's was recorded because Tammy is the one that's fine confessing because Tammy views her confession as protecting her daughter. So Tammy is on board to confess because she's going to tell a certain story that kind of omits her daughter's role in everything from her confession. So Tammy's fine confessing, and of course her confession is recorded. But Andrew's is only recorded, his interrogation is only recorded in part. So Tennessee, by law, they do not have a law requiring the recording of interrogations. It's kind of like you do or you don't, up to you. But I thought the discretion difference here was notable. So Andrew has Andrew Hayes' background. His IQ is around 62, which is testing him around a third grade reading level, like as if he was age 12. He's also been on disability. He's received SSI since his childhood, and investigators just ignore this. They don't take any further precautions. He didn't understand the first sentence of like where he signed off on his confession, but they said, oh well. And at trial, one of the detectives testified, do you know how many people at 201 Poplar, which is an address we heard in the Holly Bobo case, that's one of the jails, the correctional facilities, do you know how many people outside of 201 Poplar try to say the same thing? And they claim that they are, quote, retarded, meaning this detective just looks at it as you're looking for an excuse to walk back a confession, but you're not actually struggling with an intellectual disability or any other type of impairment that would make your signing of a confession or statement suddenly not be knowing, not be voluntary, and not be with full understanding of what you're signing off on. So these alternate suspects, once they find that there is a Wayne with a middle name Wayne, they ignore everybody. They ignore this pacemaker data. And the pacemaker data, again, was so important because it helped narrow down the window of death. But yet, as soon as this pacemaker goes up to like a heart rate of over 200 beats per minute, and then stops, like the pacemaker is fighting to keep Danny Harris alive while he's being beaten to death, then he dies. Right after that timestamp, those timestamps from the pacemaker, there's phone activity on Danny Harris's phone. And those phone calls are going to family members of the Vance, Tammy Vance. So that's a little sus. Don't you think that's a little sus? Investigators didn't seem to think it was too sus. Again, we talked about Sarah pawning stuff, and Sarah, when she testified, and this is one of the most disgusting details I think that Sarah Tinsley does a great job of covering in the podcast, is Sarah Lucas Rydell was dressed up like a church girl for her testimony at Andrew Hayes' trial. She was prim and proper. She was put on the stand to bolster the state's case against Andrew Hayes. She was just a good girl, a good girl. But then later in the podcast, I think by the time you get to episode 4 or 5, Sarah Tinsley includes recordings of Sarah Lucas Rydell and how she talks. She's calling her mom a cunt. Like, she just sounds like the nastiest person. Like, it's night and day. The recorded conversations, the little bits that we get to hear in this podcast, versus how Sarah presented herself, and I would say was presented by the state as a credible witness during the trial against Andrew Hayes. It turned my stomach listening to this detail. And I know Audrey's fake accent was in there, and listen to this podcast. That contrast was disgusting. And again, it just reminds me of Jason Autry being put up on the stand. And well, I haven't heard like recordings of Jason Autry like cursing people out or anything like that. I'm thinking of the contrast between his conversation with Dr. Katie Spirko, his recantation, versus the staccato way and scripted way and rehearsed way he testified at trial. Big, big contrast there. So, and then the jury, and I'm going to play this clip for you from the podcast about jurors being sequestered and not really understanding. We heard Hayes wasn't there, but then we got confused. Here's a little snippet of that. A little preview from episode 4 of the Everything They Missed podcast.
And I remember them saying that he wasn't there, but then implementing it that he was doing that too. It sure was confusing.
Now, I do remember the part, it was brought out how long they kept him in interrogation, but that's not saying that I knew that was the process that was supposed to happen.
It really pisses me off if you want to know the truth.
All right, so juror was speaking first, and this is Stephanie speaking now.
Didn't know more about his disability.
After a string of procedural witnesses, from the crime scene to the arrest, the state called Lieutenant Bart Ragland, one of the lead officers in Andrew's interrogation.
And as we kept talking to him, his story kept changing, like the truck.
All right, so for clarification, they're using an AI speaker or a hired speaker, I forget which one, to replicate these testimony transcripts. So this isn't Ragland's voice.
You
but
ever
it's the
seen
transcript.
Tammy with the truck? Yeah, but I never been in it. And then it was, well, yeah, I've been in it. It was just his story kept changing and changing and changing.
Reading the transcript, this is where I stopped, because Ragland was the man in the room when the recorder wasn't running. And now he was offering the jury his statement of what happened behind closed doors. He claimed no one pressured Andrew or fed him details. He just shifted on his own. He also claimed Andrew understood his rights, but also admitted in the same moment that Andrew couldn't read the first line on the page. That stuck with me, because if you can't read what's in front of you, can you really understand what you're agreeing to? However, what came next felt damning. The prosecution handed Ragland Andrew's statement and he read it out loud. Andrew's own words saying he hit Danny Harris in the head. I asked Coleman Garrett if he remembered what he thought in that moment.
So this is trial counsel. So the footage we saw, I'm not sure if that was B-roll footage that was playing of the courtroom, but this was trial attorney here.
What happens in reality and what you're told is just two different things. We got some bad cops. And I don't want to badmouth the police. That's not what I'm talking about. But they know that people that don't understand the system and don't understand the kind of pressure under those circumstances will not believe that you would confess to a murder if you didn't do it. Well,
And how many times have we heard that sentiment? You know, we started this clip with the juror saying, well, he wasn't there, but then we just didn't know. And we get Stephanie interpolating trial transcripts from the officer that did the 27-hour, at least part of the 27-hour interrogation. And the jury gets to see the statement where it's everything the detective wanted to hear. And nothing's introduced showing what happened during all of the earlier hours of that interrogation when Andrew Hayes was maintaining his innocence. So again, it's one of those moments where I would conclude, I'm comfortable concluding on my own opinion, that we were manufacturing and constructing a conviction using a false confession. So again, the amount of details, everything that we've talked about as these little notes, the way we just saw Stephanie Tinsley weave different parts together is the same thing she does with all of these other details. So I cannot speak highly enough about the work she's done with her podcast. So please check it out. Please do the deep dive. You won't regret it. So, and this is really I'll just read it. So Stephanie Tinsley ends up finding a family member that knows Tammy or knew Tammy and knows Sarah. And she goes and speaks with him. She describes her interview. You can hear his voice in some of it. I believe maybe it was a voice actor. But he's like, look, there were 2 letters I found and one isn't available. But it was describing what happened that day. There's another letter that is available and is now part of the record. And one of the quotes from the letters available in the record, the letters from Tammy to Sarah. So mom to the daughter she was trying to protect. And there's this line that says, "Sarah, I protected you from ever going to jail or prison and let an innocent man take your place. I'm not even sorry I did that because I never want to be with one of my girls in jail or prison." I mean, what do you think of a line like that? The mom who took the fall, takes a life sentence, dies in prison, is in a letter telling her daughter, and the relative says that these were like, he went over to his grandmother's house and these letters were there. It's not like something that Tammy wrote on her deathbed and handed to the Innocence Project. But yeah, crazy letter. Crazy letter. And then how do we get to where we are now? So again, we talked about the background. We know that the post-conviction reliefs have been denied at every turn. The direct appeals, the initiatives for post-conviction relief, the appeals to the Court of Appeals of the trial court's decision to deny those initiatives. State Supreme Court denied even hearing the appeal from the Court of Appeals. It just dead ends all around. Oh, I got a typo. the Shelby County. Dead ends all around. And we heard at the beginning of the stream this update from Steve Mulroy. So I think now's a good time to watch his press conference. Let's hop over and watch that. And it's my understanding that Steve Mulroy, for anyone interested, I think I saw some context that he used to be... Oh no, there's no closed captions. That sucks. Sorry there's no closed captions on this, you guys. Anyone watching on replay crew, if you're watching live, if you let this stream process, it should auto-generate some captions if you want to watch it with captions later. All right, so let's see. I'll make sure the volume's good.
Thank you all for coming. In 2007, 55-year-old Memphian Danny Harris was found murdered in his Woodchase Apartments unit in Memphis, the apparent victim of both blunt force trauma to the head and also asphyxiation. A short time after that, defendant Andrew Hayes was arrested for that crime. In 2010, a jury convicted Andrew Hayes of first-degree murder on the theory that he assisted co-defendant Tammy Vance in killing Mr. Harris. Tammy Vance had by this point already pled guilty to first-degree murder and is currently serving a life sentence. About 15 years later, evidence came to light which caused our office to take a second look at this case. Our Justice Review Unit, assisted by the Tennessee Innocence Project, did a thorough investigation. Our office has now concluded that Andrew Hayes was wrongfully convicted of that murder. The lawyers for Andrew Hayes have currently filed a pending petition to vacate his conviction. I'm announcing today that our office is not going to oppose that petition. We believe that that conviction should be vacated. Also, in addition, our investigation has led us to believe that the person who really did assist Tammy Vance in killing Mr. Harris is a woman named Sarah Lucas Rydell, who was the daughter of Tammy Vance. I'm announcing today that we have already filed charges against Ms. Rydell for facilitating that first-degree murder, and that agents of our office went to Oklahoma, where she currently resides, placed her under arrest, and our office is now actively pursuing her extradition from Oklahoma to Shelby County.
All right, I'm going to pausey McPauserton for a brief moment here and rant about the Zachary Adams case because, look, and what I'm about to say is not a criticism of Steve Mulroy. I want to contrast what he's doing here in relation to Sarah Lucas Rydell, who he thinks is the actual perpetrator of this heinous crime against Danny Harris that, you know, Andrew Hayes has been wrongfully convicted for, to the position we heard from Amy Wyrick, for example, as to why they couldn't get Jason Autry to appear for the post-conviction relief hearings for Zachary Adams. Oh, we don't know where he is. Oh, we can't ask somebody to try to transport him. And even if we could do that, he's too dangerous to transport. And he's just like, all right, well, Sarah Lucas Rydell, she's already in custody for something else. We're gonna we're going to file these charges and we're going to call up the correct facility and we're going to be like, hey, we need her extradited here because she's being charged with a murder. So a big contrast with the state's position in producing Jason Autry for the Zach Adams post-conviction relief hearings.
For trial. I want to commend the Justice Review Unit, led by Lorna McCluskey of our office, for doing a good job in this investigation regarding Andrew Hayes. I also want to commend Monica Timmerman, who is the Chief Prosecutor of Division 7. That
Monica Timmerman. So everyone's saying it looks familiar. Maybe I'm not sure. She does have a familiar face, but I don't know.
trial team in our office who is currently handling the prosecution of Sarah Lucas Rydell. You know, there are some people who have said that conviction integrity units, like the Justice Review.
Maybe this is why. So a quick search pulled up this. Maybe this is why. Because I do feel like, you know, me, this audience here, although I don't know about this story specifically, these are the types of stories that I feel like we do talk about when I'm aware of them. But Monica Timmerman had a sentence of her own. She was sentenced for a DUI and was sentenced to 11 months and 29 days in prison with all but 48 hours suspended and got credit for 18 hours time served. So maybe that's why. I mean, I feel like that's the type of thing. Again, even though I didn't come across this story, I do feel like this is the type of thing that a lot of us end up hearing about. So maybe that's it. Yep, is that one? Okay, yeah. Yeah, it was the first thing I put the name in Google or Bing, you know, and then that's what came up. So that's probably it. Also, now that I'm paused, thank you to Sheriff Chuck for the 5 gifted memberships. Super appreciate all the support. Sheriff Chuck, we're going to say he is the sponsor for why I am upgrading, why I'm doing these gamma things, and why I'm improving. So I never look at this as the way that I want to make money, but people like Sheriff Chuck, also Autry's fake accent, and even anyone that's not sending a super, not sending a gift, but is taking the time to watch this content, you guys are the reason that I'm able to start prioritizing this over my day job. And I'm calling it my day job. I work evenings on my day job, but I just call it my day job for short for you guys. So shout out to the sponsors here. Autry's fake accent said, I tried to send gift subs, but I can't send gift subs, which is weird. That's okay. Sheriff Chuck has your back. You guys are tag teaming here. And also Autry's fake accent had said, I'm watching in the bushes, but wanted to say happy Monday to my fave chat and to Kat. Hopefully we have live court tomorrow over in Fairfax County for the Brendan Banfield trial. Yeah, we'll look right before we end this stream, and we'll see if Fairfax has an update on if they're going to open tomorrow or close tomorrow. Because as of this morning, it only said closure for today. So we've got, let's see. Yeah, and Learned Hand Knit says, yep, I think that's why. I think it came up in news aggregators. Yeah, and that's actually like where I see these quick glance stories. And of course, with the news aggregators, you end up seeing, you know, at least how it's formatted for me on my news tickers. It'll be the whatever picture the publisher has set as their, you know, featured image, and then whatever article title they select. So you do see like face and quick headline, even if you don't get to look at the full story. So that would explain the familiarity here with Ms. Timmerman.
Review unit ought not to exist. I obviously disagree and believe that this case is a good refutation of that argument. I have long maintained that we need to pay special attention to trying to correct past injustices in the criminal justice system for at least 3 reasons.
At least
One,
3.
it's just the right thing to do as a matter of justice.
Heck yeah.
Second, it restores confidence in the fairness of our criminal justice system on the part of the wider community, whose help we absolutely need in the form of providing tips, reporting crimes, serving as witnesses, if we are to continue the downward trend in crime that we've enjoyed these past 7 quarters. And third, because if the wrong person is behind bars, then the right person is out there somewhere, and we need to hold them accountable. This case, I believe, is a good example of that third reason for having a unit like the Justice Review Unit. Thanks to their work, we are both assisting in righting a wrong against Mr. Hayes, but also bringing the right person to justice. You know, as a DA office, our duty is to follow the facts, even if they do challenge past outcomes. Justice isn't just about getting convictions, it's about accountability in the wider sense.
Let's run that part back real quick. Oh, we can right wrongs? We can do that? We don't just have to tighten up and say, no, don't look that way. I love that.
You know, as a DA office, our duty is to follow the facts, even if they do challenge past outcomes.
Somebody page Amy Wyrick.
Justice isn't just about getting convictions, it's about accountability in the wider sense. Whether we're seeking a conviction or confessing past error, our commitment is always the same: to the truth based on facts and evidence, and to justice based on the law. Now, I need to caution you that because there is a currently pending open prosecution against Ms. Lucas Rydell, I won't be able to get into the evidence regarding that case. What I can tell you as a general matter is that there is new evidence, and that all the evidence, old and new taken together, is specific and makes us confident that we'll be able to prove guilt beyond a reasonable doubt. We are happy to take any questions.
Now that Hayes, we're saying that he was not, guilty of his crime, what would you say to him, now that he's, had several years of his life taken away, but now we're sort of turning it around?
Well, of course.
Okay, so this question's hard to hear, but the question, I don't know the exact words, but he's asking, what would you say to this man who was convicted that's lost years of his life?
Of course, we regret that, right? I mean, it is an injustice. Any wrongful conviction is to be regretted, and we certainly regret what has happened to him.
What was the evidence at Mr. Hayes' trial that convicted him if we are now saying that he was wrongfully convicted?
All right, so what was the evidence at trial that convicted Mr. Hayes and that you're now saying he was wrongfully convicted for?
Well,
Well,
I guess the main evidence was the fact that Mr. Hayes did confess. We believe that was a wrongful, false confession. It was the product of a 27-hour interrogation of a person who was intellectually disabled, whose IQ was below 70.
Andrew Hayes' IQ.
Andrew Hayes, yes. Furthermore, there were several inconsistencies between the confession itself changed over the many hours of interrogation, but the final version of the confession that was used by the state at trial was inconsistent with the physical evidence at the crime scene in several important respects. So, for example, he said there was no blood, there was plenty of blood. He talked about it being in an upstairs apartment, was on the ground floor. He talked about hitting the victim on the back of the head with a hammer. There was no such injury on the back of the head, et cetera, et cetera. I will also point out, and this is all a matter of public record, that the original trial, Tammy Vance testified and said that Andrew Hayes did not assist her, that it was her daughter that did so.
What was the connection?
all right, yeah, so let me clarify. Okay, I had the hammer detail wrong, but whatever it was that Sarah ended up, the story now is that Sarah, whatever was the fatal injury Sarah inflicted, is the theory now, because she didn't like what Danny Harris had done and or said to her mother, Tammy. So I think I mixed up the hammer detail from these two pieces here.
Connection between Hayes and Vance, like how did they know each other?
All right, so how did Hayes and Vance know each other?
Well, so, we're not sure that they knew each other prior to the murder. But sometime after the murder, the evidence seems to suggest, at least from the original trial, that Tammy Vance moved into the same apartment where there were a number of people all sharing housing, and Andrew Hayes happened to be one of those people. He happened to simply be present, giving somebody a ride to the police station when Sarah Lucas and Tammy Vance were called into the police station for questioning. I will point out, just to be clear as to my answer to the Lucas's question, it is counterintuitive to think that anyone might ever do anything like falsely confess. But it is nonetheless the grim reality that false confessions do happen.
Tell him.
There are a number of instances where that has been proven to be the case, and where they do happen, they tend to be correlated with things like prolonged interrogation sessions and a vulnerable defendant, either an underage defendant or, in this case, an intellectually disabled defendant. And I think this is a useful cautionary tale about that. I'm not saying that most confessions are false. I'm sure most confessions are valid, but it is something that we need to be mindful of.
Was this an interrogation that was conducted by Memphis police?
It was.
Will there be any looking back at that on how that was
We're not
already happened?
We're not focused on that. We're focused on two things: righting the wrong regarding Andrew Hayes and bringing to justice the person that we think is responsible for assisting Tammy Vance in that murder.
What was Vance's relationship to the victim? Are you allowed to say that? Don't tell me about Sarah.
Yeah, I mean, the public record from the original trial indicated that she was his girlfriend and at various times was living with the victim.
You said that physical evidence was incongruent with Mr. Hayes's confession and testimony in that confession. What responsibility do prosecutors have when it comes to those incongruencies and presenting those at a trial?
I mean, that's a good question. You know, I think going forward, our office is going to be very mindful of the fact that sometimes confessions can be false. Usually they're not. I don't want to overstate it. Most confessions are valid. They're very useful information in our prosecutions, and we will continue to use them. But we need to be mindful that there are certain factors that might be red flags.
And talk about the dangers of a false confession. You know, this is a convicted killer that's probably convicted. A person who killed someone who's, you know, on the lam right now, and we have someone who's wrong. Like, the danger of that, the killer is still out there.
Yeah. I mean, I think that's right, and it goes to that third reason I was giving for having something like the Justice Review Unit, a Conviction Integrity Unit, because when we have a false confession, or any of the other things that sometimes lead to wrongful convictions, like witness misidentification or problems with forensic evidence, or all the things that tend to lead to wrongful convictions, including false confessions, we have that problem. That the wrong person's behind bars and the right person is still out there. Now, depending on the facts, that person could still be committing more crimes. So there's a real public safety need for us to get these things right and to fix these problems when we've uncovered indications. Now, whether that's true in this case or not, nonetheless, when the wrong person's behind bars, the right person still hasn't been held accountable.
This may speak to the evidence that was found, so maybe you can't say anything, but you also mentioned that Tammy Vance had confessed as well, right? So on one hand, we have two people that confess, but one is false, the other is not. So what is kind of the...
All right, so this question is, we have Tammy Vance's confession. So on one hand, we're saying that Andrew Hayes' confession is false, but the other is not.
The difference.
Well, I would say one thing, that the trial record from the original trial, the public record, the publicly available information, doesn't have any inconsistencies between the physical evidence at the crime scene and the confession in the case of Tammy Vance that were present in Mr. Hayes.
You said we're waiting to bring Sarah Lucas here. When can we expect her to be brought here, and what's the next steps as that starts moving forward?
Yeah, that's a very good question. We're trying to move things along as quickly as possible out of courtesy to the law enforcement folks over in Oklahoma. Ms. Timmerman, do you have any answer to that?
We are hopeful. Our office, we have prepared all the paperwork that was required of us, and I believe that has been transmitted to the state AG's office that gets the governor's warrant that they will then transmit to Oklahoma. My hope is that she will be here by the end of the month, but it may be into February before she gets here. She has been charged in Oklahoma with the fugitive from justice case. And from the time that that happens, we have 90 days to get her here. She was charged with that in December. And I think her next court date on that is March 1st in Stevens County, Oklahoma. But we are hopeful to have her back in Shelby County prior to that date.
Has Ms. Rydell been cooperative with the investigation?
Not particularly.
So the question was, has Ms. Rydell been cooperative?
Cooperative with the investigation?
Not particularly. Yeah. She
has not agreed to waive extradition.
Right. She hasn't agreed to waive extradition, and she has not given a statement in her case.
Going back to Mr. Hayes, you said that the Tennessee Innocence Project is representing him.
Mhm.
I would imagine that this is some sort of collateral review case. I know we've kind of been in a weird space with that where it might be the AG's office handling those cases now. You said your office won't stand in the way of this collateral review case. Do you know if the AG's office, if they have any stake in this case, if they will be stepping aside as well?
So this is not a capital case. So that law that was passed in 2023 that transfers post-conviction authority away from the locally elected DAs to the unelected Attorney General doesn't apply. Okay? So we validly have the case right now. And I've spoken to a representative of the Attorney General's office and let them know in advance what we were doing. You know, as a general rule, unless there is some problem with jurisdiction, generally the Attorney General's office will not try to appeal cases where we have agreed. And I am hopeful that that will be the case here.
What is a typical timeline on a case like this? I mean, Hayes is currently in custody, and so what would be a timeline for him getting out and having wrapped up?
Well, I mean, a post-conviction like this could take years. In this particular instance, we'll be filing a response fairly soon to indicate that we don't oppose. Hopefully that will speed things along, given that we believe that the person is wrongfully convicted. You know, we certainly would be in favor of a pretty speedy resolution so that he could be released.
Love to hear it.
Okay, exactly how long has Mr. Hayes been in prison?
Since 2010, right? So, is that right?
Well, he was convicted in 2010, but I believe he was arrested in 2007.
Ah,
How much time was he given? I think we said he was convicted of first-degree murder, but what was the sentence?
it was a life sentence, was it?
Yes, it was.
It was and I should mention, you know, you mentioned the Tennessee Innocence Project. You know, they're the ones that currently have pending the petition for vacating the conviction. And that's a public record. You know, if you want to find out more, you could always go to that public record.
Will you guys be assisting? I'm sorry. Will you guys be assisting Mr. Hayes as he makes this transition from, you know, back to normal life again? That can probably be difficult for a person coming out.
Well, that's not something that our office normally does. You know, I would imagine that there are other places that can do that kind of thing.
What was
Oh, so I think the question you're asking about is, so how long has Andrew Hayes been incarcerated? So I think the 17 counter is now up to 18 years. Based on the statement that we read from Jeff, the attorney, it seems like 18 now, not 17. So I've got to update everything.
A feeling when you found out that there was a mistake?
Oh, now, hold on. What was that question?
You found.
I would imagine that there are other places that can do that kind of thing.
What was the feeling when you found out that there was a mistake?
What was the feeling when you finally caught, I think he says, finally caught that there was a mistake?
In the office, was it a surprise? Or what was the feeling and then what were the steps?
Well, I wasn't pleased to find out that there had been a miscarriage in justice in the Shelby County criminal justice system. But I'm not going to say I was shocked either. You know, both in Shelby County and around the country, there are wrongful convictions. They take place. They don't take place in most cases, but they're not freakishly rare. And so I guess I will say I was displeased, but not shocked.
I love that we're not pretending that, oh, this is a unicorn. This is a unicorn. It like never happens. He's like, it's not, every single case doesn't have a wrongful conviction story. We mostly get it right, but there's a lot more wrongful convictions that we can't just say it's freakishly rare.
All right.
Thank you all very much.
Thank you.
Oh, all right. Oh, ears. Sorry, guys. Sorry. Autoplay got us. I wanted to jump over to another clip from the Everything They Miss podcast to give you a little, and I thought of it when they were talking about the cooperation, whether or not that question about whether or not Sarah was being cooperative with this extradition from Oklahoma. And this little clip that I went and found quickly, I believe the backstory is Tinsley ends up deciding to hire an investigator to try to, actually no, it was someone with the Tennessee Innocence Project that tries to reach out to Sarah Lucas Rydell after they'd gotten a contact number from a relative or a friend. Let's
and Tammy, anything that could shed further light on what people knew about this.
That's when he hit play on a tape I thought I'd never hear. And I have to warn you, it's raw and vulgar and shocking. And it's been sealed off from the public for years, never broadcast or shared until now. Because Jason's team didn't just stack up affidavits from Sarah's family, they landed a call with Sarah herself.
listen to Sarah, who was dressed like a church girl at the
My
trial.
nephew, let me explain to you. The that's sitting in jail did what he did. If this shit don't stop, I'll be to sue the pants out of your little justice system. Do you understand me?
And the caption's wrong. It's supposed to say sue, not see.
Did? If this shit don't stop, I'll be to sue the pants out of your little justice system. Do you understand me?
You could feel free to sue whoever you'd like, but our investigation will continue.
For what? I didn't do anything.
Well, that's still our investigation.
In 2023, the Tennessee Innocence Project tapped Memphis defense attorney Mark Caudell to chase the story's loose ends. He started with tracking down members of Tammy and Sarah's family. Some would talk, but the ones that did warned him. If Sarah caught wind of this, she'd retaliate. Then, out of the blue, while Mark was on mid-drive on the open highway, she did.
And who exactly are you?
Well, you apparently know who I am if you're calling me.
No, I just knew that my niece, Gracie, that you spoke with, said that you were Justice something.
Yeah, I work with the Tennessee Innocence Project.
And you're going to get him out of there, and he killed a man, huh?
That's to be determined.
But you're running around, running my name all through towns and states. I'm going to sue the fuck out of y'all.
Okay.
That is slander. Do you understand that?
I haven't said you've done anything.
Okay, well, they're telling me that you're asking questions about me for what? That shit was closed years ago with Mullins and everybody else.
Well, it's open again.
And who let you open it?
We opened it. And, we're just doing an investigation right now.
You know, I'm just trying to live my life. My mom put me in a bunch of shit because she was a piece of shit, is what my mother was.
So remember, Tammy Vance confesses and takes a life sentence to keep her daughter out of prison. And granted, she still has her own culpability, maybe, covering up, letting another innocent man go to prison. But as far as if we just box this into just a discussion of Tammy and Sarah, this is how Sarah's speaking about her mom who took the fall for her.
She put my sister Heather, that passed away on November 2nd of a year ago, in jail for lies.
Okay.
You don't know Tammy Jean Vance at all. And you don't know the little she run around with and every dick she stuffed and fucked all over town to get her fucking way. I do. I'm her daughter. She was nothing but a slut, a piece of shit mother and grandmother.
Oh, I mean...
Why are you asking questions about me, though?
Because I'm conducting an investigation.
And who else are you asking questions about? Am I the only one?
I'm not able to tell you that.
I'm letting this tape.
Woo! So I'm telling you, and again, this isn't even like the craziest thing that Stephanie has put together. So please, please, please take the time to listen to this podcast. Especially another good time to take a segue here. It looks like, and thank you for the updates in the chat, you guys. Learned Hand Knits was like, hey, one of the courts is closed tomorrow. So I looked and it says on the Fairfax County government website that all courts, all government offices and all courts are closed, not just today on Monday, but also Tuesday, the 27th. So no au pair trial tomorrow. So you guys, if you're looking for something to do, since that court won't be in session tomorrow, check out the Everything They Miss podcast. But yeah, what do you guys think? What do you guys think of Miss Sarah Lucas Rydell? And it seems like that recording was from like maybe 2023, 2024. I'm not sure on the exact date. Stephanie just says we started trying to look at this in 2023. But now we know that Shelby County wants to charge her, has charged her, and it seems like they expect that she'll be extradited by the end of January, which is, we'll find out. I'll keep looking for an update. But yeah, what a character, huh? What a character. So the daughter is, yes, so Sarah, the daughter is, it's now the theory that she actually did it. She hasn't been tried yet, I think everything that I've seen presented in this podcast and what I've been looking at supports. I think it's good charges against her. I wouldn't be surprised if she gets convicted. But technically she still has to have her day in court. But that is the theory now, that the daughter actually did it. Tammy Vance took the fall for it to protect her daughter. And Andrew Hayes just got roped up into it because they heard the name Wayne, and Andrew's middle name is Wayne. Yeah, so the victim was the on and off again boyfriend of Tammy Vance. So Danny Harris was using MegaMate's teleconference line, Telemates. That's where he initially met Tammy. They hung out a little bit more. It seems like she lived with him for a time, maybe on and off. So yes, there was a relationship between Tammy and the victim, Danny Harris. Brooklyn says, I wish I can get Terry Britt's phone number. Which phone? Which one of his phones? Which one of his phones? Curious Lee says, what a delightful lady. Whew, crazy. Crazy. Yes, Law Kong Express. Sarah at trial presented as a Sunday school teacher. Just very, very demure. So, yes, the old chat lines. The old chat lines. All right, so we just got done watching like a press conference from this month from Steve Mulroy. But we heard he was convicted in 2010. Why are we in 2026 finally getting to a point where there's light at the end of the tunnel, where we have this wrongful conviction, it might be overturned? In 2012, the direct appeal was exhausted, so it was denied. It was filed after the conviction, so December 23rd, 2010. And then we have a decision in August 6th of 2012 affirming the conviction. So the direct appeal denied. This I thought was interesting. We're looking at the Court of Appeals here. Is this where we see a familiar name? Oh, it's the next one. We don't quite have a familiar name quite yet. Let's see. So this is appealed. Let's see. The application to the state Supreme Court for the state Supreme Court to hear this appeal was denied. They don't even want to hear it. They don't even take the case. In 2013, we have the petition for post-conviction relief, the first one. The attorney here is James Jones Jr. This bothered me because while it's not unusual for someone to file like an extension or request for an extension of time to file, the appeal brief or a response to one, it got excessive here. So the initial petition was filed on January 14th of 2013. We end up having an amended petition, we have an amended petition filed on November 7th of 2014. So that's a huge gap in time. There's a hearing on June 15th, 2015. You see how long these processes take? So the request for post-conviction relief is then denied. And again, we're up in 2015 now. This is like 2 years and change after this petition was filed. October 5th, 2015, Judge Paula Scahan denies this request for post-conviction relief. And then to appeal this decision from the trial court level to the Court of Appeals, they had a deadline. They had like a 30-day deadline to file this request. Attorney Jones missed the notice of appeal deadline. So there was this request here for a waiver of timely filing filed on February 10th of 2016. And the court's going to grant this, but I want to take a look at it because I think it's important to think about if you were sitting wrongfully incarcerated and years are going by with this. Like, look at these dates just flying by casually. So, again, this is the motion from Attorney Jones to waive the timely filing. So, a Shelby County grand jury in the underlying case indicted defendant for the offense of felony murder and perpetration of an aggravated robbery and aggravated robbery. Defendant was tried before a jury and found guilty as charged on August 21st, 2009. And I think this date is wrong because everywhere else says 2010. But Who knows? At trial, defendant was represented by attorney Coleman Garrett, who was appointed to represent Mr. Hayes. A sentencing hearing was conducted in front of the Honorable Carolyn Blackett, of which the judgment sheet reflects that the trial court sentenced defendant to life in prison with the possibility of parole for the felony murder charge and 20 years for the aggravated robbery charge. The Court of Criminal Appeals later affirmed said judgment on March 2012. On January, and we read some of this timeline, but again, like, this is years going by for this initiative. So we have Mr. Turner filed a petition for post-conviction relief in the Criminal Court of Shelby County for the 30th Judicial District, asserting ineffective assistance of counsel. And then Attorney James Jones was appointed on November 7th, 2014, and he filed the amended petition. Again, we heard that the hearing happened on June 15th, all the way in 2015. So they put on the proof saying, hey, post-conviction relief is warranted, and then the request is denied on October 5th of 2015. And then we're asking, like, hey, we missed our deadline to file an appeal of this decision from Judge Paula Scahan. So Tennessee Rules of Criminal Procedure say that, hey, we can appeal any order of judgment, and then the notice has to be within 30 days after the date of entry of the judgment. So let's see. Citing to this Rockwell case, waiver is not automatic and should only occur when the interest of justice mandates waiver. So we're asking you to waive this timeline, this deadline. And even though you aren't automatically supposed to grant a waiver of our failure, like an extension to file this notice, you can when there's an interest of justice. So this is supposed to be an argument that in the interest of justice, you should overlook that we failed to file a timely notice of appeal. So they make this argument that in this present case, Mr. Jones should have filed their notice of appeal within 30 days of October 5th, 2015, which was the day the defendant's petition for post-conviction relief was denied. Due to unexpected and significant events affecting counsel, which are further explained in this motion, said notice was not filed timely. So attorneys falling on their own sword, defendant respectfully asks this court in the interest of justice, which is the basis they've got to argue, to waive the timely filing of the notice of appeal. In the present case, a clerical error has caused a delay in the notice of appeal being submitted to the court. At the conclusion of the post-conviction hearing on June 15th, 2015, Judge Scahan reset the matter to render her decision on October 5th, 2015. Counsel, having other matters in Judge Scahan's court the week prior to Judge Scahan rendering her decision, learned that Judge Scahan would not be on the bench due to personal matters, and that Mr. Hayes' case would be reset to December 4th, 2015 to have the decision rendered. Counsel appeared on December 4th and was instructed by the clerk that no order was in the jacket and that counsel should return the following week. Counsel returned the following week before the court shut down for the holidays, and there was still no order in the jacket. So counsel again approached the clerk and judge on January 19th, 2016 to inquire as to the order and learned from the judge that she'd actually issued her order in October and was under the impression that the clerk had notified and turned over said order to counsel. So this attorney is laying out like, hey, I was showing up and I kept asking. The judge and counsel learned at that time that neither of those things happened. So the clerk didn't notify and turn over these orders. Counsel pulled the jacket on the date and there was still no order in the jacket and was instructed to come back the following week to allow the clerk time to figure out what happened with the order. So long story short, they go through all of this, and as far as this particular issue, where were we in this document? I think we scrolled here. It's granted. So this ends up being granted in February of 2016, but then there's multiple more requests for an extension to file the brief. And the court finally issues a final deadline of December 30th, 2016. So again, this initial petition is filed in January of 2013. In the early months of 2016, Attorney Jones is like, look, I missed the deadline, but there's a good reason. And the court agrees. And they're like, all right, we're going to grant an extension. That was granted in February of 2016. Somehow, nothing gets filed. No brief gets filed for the rest of the year. And the court's like, look, you have a final deadline. I'm going to grant a final extension for December 30th, 2016. So this is almost 3 years later. That's the deadline. You've got to get this brief filed. But then the brief isn't filed and the court issues an order to show cause. So we are now in February of 2017, and we finally end up getting the brief filed, and then the court, I think like 6 or 7 days later, gets rid of the order to show cause. They dismiss the order to show cause for Attorney Jones. So this wasn't his fault, but then we have like a year and a deadline, a final deadline that's missed, and then finally this brief gets submitted in February of 2017. So, and what I thought was interesting is, I'm not sure if this is significant, but for the other appeals, there's like 90 exhibits submitted, the transcript volumes. I think there's like 11 volumes of the transcript. There's just a lot more that was submitted as part of the record. But for what I saw for this saga, for the petition for post-conviction relief initiated in 2013, didn't look like very much was filed. And I don't know if that's what should be expected, but as a non-lawyer, for this number to be so low compared to what the record that was provided in other actions, this seemed a bit odd to me. But anyway, so this gets denied, and then Attorney Jones files an application to the state court to appeal the Court of Appeals decision, and the state court doesn't want to hear it. So they don't even hear the case. So we move on to 2017. Let's see. Actually, this is the same thing. Sorry. This was the decision to deny. So let's take a look at that. And I guess Gamma put it in its own little summary bubble. Let's see. Open this up. What's the reason for denying? All right, there we go. So we've got, again, this is coming down. This is filed June 28th of 2017. This is an appeal of Paula Scahan's decision. So we're now at the Court of Appeals, appealing her decision. So the petitioner, Andrew Hayes, appeals the denial of his petition for post-conviction relief from his first-degree felony murder and aggravated robbery convictions, arguing that the post-conviction court erred in finding he received effective assistance of trial counsel. Following our review, we affirm the denial of the petition. So it's an appeal of the judge's decision. So we've got Alan E. Glenn delivers the opinion of the court, in which Timothy L. Easter and J. Ross Dyer join in. Let's see. James Jones is the attorney for the appellant. And who's representing the state of Tennessee here? We've got Herbert H. Slattery III, the attorney general and reporter. We've got Jeffrey D. Zentner, assistant attorney general. We've got Amy P. Wyrick, district attorney general, and Muriel Malone, or Maloney, who knows, assistant district attorney general for the appellee for the state of Tennessee. So we've got Amy, and I would love to know her opinion on the power of the podcast. I hope she's insulted by the everything they missed name. So we've got opinion. This is just going to go over the background. So he was convicted of the 2007 murder and the robbery. Our direct appeal opinion reveals that the victim's decomposing body was discovered at his Memphis apartment on October 26, 2007. The medical examiner ruled that the cause of death was, quote, blunt force injuries of the head and asphyxia, and a computer analysis of the victim's pacemaker indicated that all heart activity had ceased on August 20th, 2007. The petitioner was developed as a suspect after his girlfriend's mother, Janice Jefferson, who was known as Snow, reported to the police that the victim's girlfriend had been selling the victim's possessions. So we have a footnote from this part. It says, in order to avoid confusion, we have elected to follow the direct appeal opinions practice of referring to Miss Janice Jefferson by her nickname, Snow. So we're using nicknames throughout this. At the time, the petitioner lived in Snow's home with Snow and her daughter, Shawana Jefferson, who was the petitioner's girlfriend. A short while earlier, the home had also been occupied by the following individuals: the victim's girlfriend, Tammy Vance, Miss Vance's daughter, Sarah Lucas, and Miss Lucas's boyfriend, Miguel. When Miss Vance moved into the home toward the end of August 2007, she had a black eye and a scratch on her face. Miss Vance informed Snow, so Tammy Vance is speaking to Snow, who's Andrew's girlfriend's mom. So Tammy Vance is speaking to Andrew's girlfriend's mom, that the victim had hit her in the eye because he was drinking. So Tammy Vance tells Snow that Danny Harris, the victim, hit her, and that's why she had a black eye, and that he had, as a consequence, recently entered rehab. During the time they lived in the home, Miss Vance and her daughter were driving a real nice truck. According to Snow's trial testimony, the two women informed her that the vehicle belonged to the victim, who had given them permission to drive it while he was in rehab. Snow eventually asked the trio to move out because they were not paying their portion of the utility bill. According to Snow, Miss Vance offered her a handgun as payment and also brought her a television that she claimed she had been given by a woman who lived around the corner. Later, Miss Vance sought Snow's assistance in selling the handgun and the victim's truck, telling Snow that the victim was going to be in rehab longer than initially planned, and had instructed her to sell the items. The petitioner, we got some booze here for Amy. She's so popular, she's in all these cases. The petitioner, who was not initially a suspect, was interviewed by police detectives because they believed, quote, he had relevant information, due to his involvement with Miss Vance and her daughter. Our direct appeal opinion provides the following summary of the detective's trial testimony with respect to those interviews. So during the first interview, the petitioner, so Andrew's story, quote, story kept changing and changing and changing. We heard a voice reader of Lieutenant Bart Ragland of the Memphis Police Department's testimony. And he said at that point, quote, it became obvious that he knew more than he was telling and that he had more involvement than just being a witness. So they provided Andrew with Miranda warnings. Andrew had some difficulty reading the advice on the rights form. So Lieutenant Ragland, quote, read the entire thing to him and he understood it and we went over it. So the Court of Appeals is relying here on Lieutenant Ragland's representation that he understood. He understood his rights. Andrew executed a written waiver of his rights at 3:15 p.m. on November 2nd, 2007, and he provided a statement at 5:57 p.m. that same day, implicating Tammy Vance in the victim's murder, telling officers that he traveled with Tammy Vance and Sarah Lucas Rydell's boyfriend, to an apartment in Cordova to get a 36-inch television. The petitioner, I almost said Zachary, Andrew, told officers that he opened a closed bedroom door inside the apartment because he smelled the foul odor and that he saw the victim's body laying in the bed. He said Ms. Vance, so Tammy, told him not to worry about the body because she and Miguel were going to take care of it. Andrew described the body as a white male. He was laying on his left side. He was about in his mid-50s. He was medium build. His skin was turning black. His hair was brown, and he had a mustache too. He said that he did not notice anything in the victim's mouth or any blood in the room. He said that he and Miguel loaded the television into the victim's truck, and that Miss Vance also removed a VCR and a DVD player that was built together and DVD movies. He said that they left the victim's apartment and traveled back to the DePass Street residence to pick up Miss Lucas. So this is Sarah. They're saying they go and pick up Sarah so that Miss Lucas could pawn the items. Andrew told Lieutenant Ragland that he did not tell anyone about seeing the corpse in the apartment because he was afraid that he would be charged with the victim's murder because he'd helped move the television. Lieutenant Ragland said the fact that Andrew was able to describe the victim as a white male was suspicious. Are you ready, chat? Because, quote, the state of decomposition of the victim at the time made it difficult to tell that he was indeed a white male. Lieutenant Ragland said that he spoke with the petitioner on a second occasion and that the petitioner gave a statement, but he stopped, and he refused to sign the statement. Between the giving of the two statements, Lieutenant Mullins, quote, interviewed the petitioner, and it became apparent that he had more involvement than he had originally admitted. During the taking of the second statement, the petitioner initially, quote, admitted that he had actually been involved and hit the victim with a steel pipe before he recanted and said that no, he didn't actually do it. Following his recantation, Andrew became hysterical and started crying, and at that point, it became obvious that officers couldn't talk to him anymore. Shortly thereafter, I'm assuming this was in the quote. Shortly thereafter, Andrew was booked into the jail on a 48-hour hold. Lieutenant Ragland said that he became suspicious of the petitioner when the details of his statements changed over tellings. Lieutenant Ragland admitted that he was not present when Andrew first admitted striking the victim with a pipe. He said that after recanting his admission of his murder, Andrew blamed the victim's murder on Wayne Bobo, Snow, and Miss Jefferson. He said that the petitioner became hysterical and that it was impossible to continue the interrogation. Lieutenant Ragland denied that Andrew was upset at being accused of a crime he did not commit and said that the petitioner was upset because he'd admitted to his involvement and he knew he was up shit creek without a paddle. That's why. He said that Andrew immediately began recanting and blaming others because that's what criminals do. Memphis Police Department Sergeant Anthony Mullins testified that he became involved in the investigation when he arrived at the scene. Later, Sergeant Mullins interviewed the petitioner petitioner is Andrew, I'm using them interchangeably. I think it's easier to say Andrew. He interviewed Andrew after Andrew was developed as a possible suspect. He recalled that when he first came into contact with Andrew, Andrew was in Lieutenant Tony Armstrong's office. During that encounter, Andrew could describe things in the apartment and describe things that happened, and the more we asked him about what happened, he gave particular details that no one would know unless they committed the act. So he can't give these details until like hours and hours go by in this interrogation, and suddenly he's able to give these details. Do you wonder how he got those details? And yeah, Glennon, I would be hysterical too. I'd be hysterical after probably like 4 hours. I think 4 hours might be my limit. Like, as soon as I needed to pee, I'd be like, let's go. Sergeant Mullins said that upon further questioning, Andrew admitted killing the victim, telling officers. They went there, him and Tammy Vance, to rob Danny Harris. And when they got inside, an argument ensued. Danny Harris wanted to know why they were there, how they got in his apartment, because Miss Vance had a key. And during the argument, Tammy Vance threw a container of bleach at Danny Harris, and then he said he struck Danny Harris in the head with an iron pipe, pushed him in the bedroom, and struck him again and again and again. Ultimately, he said between 7 and 9 times. Sergeant Mullins said that the petitioner's statement explained some of the things that police had seen in the victim's apartment, like the rag in the victim's mouth, which Andrew said Ms. Vance had stuck in the victim's mouth to stop him from screaming. And remember, his initial statement, we read earlier in this order, this decision, this opinion, that Andrew at first doesn't recount anything mentioning the cloth shoved in the mouth. Sergeant Mullins said that when they started to take a formal statement the second time, Andrew was getting some details wrong, such as the location of the victim's apartment. When Sergeant Mullins questioned Andrew about the mistakes, Andrew became very upset and said that people have threatened him about this incident. Andrew then blamed Wayne Bobo and an individual named Miguel for the victim's murder, but continued to acknowledge that he was present during the murder. During this time, Andrew was loudly crying and yelling. When it became apparent that they would be unable to obtain a statement from Andrew, they took him down to the jail on a hold because they felt like they had sufficient proof to charge him, but weren't prepared to charge him at that point. Sergeant Mullins testified that officers brought Andrew to the homicide office for another interview on the following morning. Andrew was provided Miranda warnings a second time. At that point, Andrew provided a statement admitting that he murdered the victim by striking him with a metal pipe about 7 to 8 times on the head. He said that he went to the victim's apartment to rob him. Tammy said to ride with her to rob her boyfriend. Andrew admitted, I struck him the first time with the pipe. She grabbed Danny Harris by the mouth and shoved a face towel in his mouth. Andrew said that he did not get blood on him and that Miss Vance threw the murder weapon into the Wolf River. All right, so back to the opinion. In his defense, the petitioner presented the testimony of Dr. Randy Schnell, the clinical services coordinator of the Memphis City Schools Mental Health Center, who identified a psychoeducational evaluation performed on Andrew to determine his eligibility for special education services. Dr. Schnell testified that the petitioner's IQ in 1992, when the petitioner was 14, was only 62, which was consistent with mental retardation. He said it was extremely unlikely that the petitioner's IQ score would have increased to normal levels by adulthood. The petitioner, testifying in his own defense, denied any involvement in the murder and claimed that he made the incriminating statements because the police officers kept him in the interrogation room for hours, screamed at him, and told him that Miss Vance had accused him of the murder. The petitioner also presented as a defense witness Tammy Vance, who acknowledged that she'd pled guilty to the first-degree murder and aggravated robbery of the victim, but denied that she had killed the victim and instead blamed the murder on her daughter, Miss Lucas. Miss Vance testified that she first met the petitioner several days after the murder when she and Miss Lucas returned to the victim's apartment to retrieve the victim's television set. She said she blamed the murder on the petitioner when she was being questioned by the police because officers told her that Andrew had confessed and she was trying to protect Miss Lucas. So you've got these officers like saying, "Hey, Andrew, Tammy Vance is saying you did it," and then they're going to Vance and saying, "Hey, Tammy Vance, Andrew's saying that he's confessed to it. Andrew's already confessed. And you're trying to protect your daughter." So, on January 14th, 2013, Andrew filed a pro se petition for post-conviction relief in which he alleged he was denied the effective assistance of trial counsel. Following the appointment of post-conviction counsel, he filed, and we just looked at this timeline, he filed an amended petition in which he alleged that trial counsel was ineffective for, among other things, failing to have a mental health evaluation performed on the petitioner, despite knowing of the petitioner's history of mental health issues. Also, for failing to investigate and call as a trial witness a woman who could have testified that it was other individuals, and not the petitioner, who removed items from the victim's residence. Also, for failing to strike a juror who was a work colleague of one of the victim's sons. So, there's actually a juror who worked, I think, for the sheriff's office. It was for a law enforcement agency. I forget, they talk about it in the podcast. And she is on the deliberating jury. They don't strike her. But she works with the son of the victim. One of the sons of the victim. And also for failing to test a bloody fingerprint found at the crime scene against the fingerprints of Sarah Lucas. So they don't test these things. They don't try to match these fingerprints and put them up against Sarah Lucas's fingerprints. At the evidentiary hearing, Clark Chapman, the private investigator who was appointed to assist defense counsel, testified that he learned that the petitioner had numerous learning disabilities and nervous issues throughout his childhood, and as an adult, had been receiving disability benefits since the age of 12 or 13. Mr. Chapman identified the petitioner's school mental health professional report, which he said he turned over to trial counsel approximately 8 or 9 months prior to trial. He testified he interviewed 15 to 20 witnesses during the course of his investigation, including Frances Wheeler, the woman who owned the house where the petitioner was living. So Frances Wheeler, I think, is the one then who noticed that Danny Harris hadn't been paying his rent and called in a wellness check. So that's how they end up finding his body deceased 2 months later. So Chapman learned of her late in the case and interviewed her close to the time of trial. Miss Wheeler informed him that she'd gone to the petitioner's home one morning because the petitioner was supposed to help roof one of her rental properties. The petitioner was still asleep when she arrived, and she instructed one of the other residents of the home to wake up the petitioner. As she waited for the petitioner, Tammy Vance and her daughter arrived in the victim's truck with a large-screen television in the back of the truck. According to Miss Wheeler, the petitioner came out of the house and helped the women unload the television. Oh, so I'm getting the witnesses. The story's correct, but this is a different landlord. This Frances Wheeler is the landlord for where Snow and Andrew were living. But whoever was the landlord for Danny Harris ends up calling in a wellness check. That's how Danny's body's found. But Frances Wheeler is different. Frances Wheeler is the property owner for where Andrew's staying. So Frances observes all of this, and then says that Andrew came out of the house and helps the women unload the television. But what's critical about this is Tammy and her daughter show up with the large screen television. Petitioner wasn't in the truck driving with them with the TV in the back. He just comes out of the house to help them unload it once they already have it. So we've got, let's see. Mr. Chapman testified that he believed Miss Wheeler's account coincided with the information he received from Miss Tammy Vance, who confessed to him that it was her daughter and not the petitioner who had killed the victim. He said he called trial counsel and informed him of what Miss Wheeler had told him. He stated that trial counsel was not present during his interview with Miss Wheeler and, to his knowledge, never interviewed Miss Wheeler himself. He said that trial counsel was confident that the case would either settle before they went to trial or would just go away, and did not think they needed anything else. On cross-examination, Mr. Chapman testified that he spoke with the petitioner throughout his preparation of the case, and that the petitioner appeared to be engaged in the investigative process and to understand everything he said to him. He said he thought that Miss Wheeler would have been an instrumental witness in identifying who had the TV that morning, and as such would have corroborated Miss Vance's story that her daughter had killed the victim with a hammer. He acknowledged, however, that trial counsel had cross-examined Miss Vance about her contention that her daughter was the perpetrator. On redirect, Mr. Chapman, so during this post-conviction hearing, when it's the state's turn to question Chapman, they're like, "Are you aware that the jury got to hear this information?" Yeah, I do concede that, at trial, the attorney did ask Ms. Vance about saying that Sarah was the perpetrator, so the jury did get to hear that. On redirect during this post-conviction hearing, Mr. Chapman explained that Miss Wheeler's testimony, that the two women brought the television to the house alone, was significant because the state's theory was that Miss Vance had to have the petitioner's help in loading the television. So from Danny Harris's residence into the truck at that residence. So that's a contradiction. In addition to Miss Wheeler, he also thought that the defense should have had a physician appointed to investigate the petitioner's mental health issues. He stated that the defense team contacted a doctor to perform a mental health evaluation on the petitioner, but the physician backed out, citing a conflict of interest. To his knowledge, no one else was ever appointed to take the physician's place. On recross, Mr. Chapman acknowledged that the petitioner provided details in his statement to police that were consistent with the physical evidence at the crime scene. He further acknowledged that the petitioner said during cross-examination that the prosecutor would not be able to make him say anything he did not want to say. So at the trial, Andrew Hayes takes a stand in his own defense. So he testifies in his own trial. And he loses his cool with the prosecution. And they go through these trial transcripts in the Everything They Missed podcast. But he loses his cool, and he ends up telling the prosecutor, "You're not going to make me say what you want me to say." Which, if you're sitting there as a jury, that can be an interesting thing to hear when you're also being asked to consider that somebody would tell an officer during interrogation what they wanted to say. And I can understand it. I can understand losing your cool in the moment and saying something like that. And then also, in another occasion, telling somebody what they want to say. But state hinged on this and asks during these post-conviction proceedings, Mr. Chapman, "Are you aware that during trial, the jury heard petitioner himself say this, that nobody could make him say something he didn't want to say?" So he explained, however, that the petitioner had felt comfortable at trial because he was in the presence of trial counsel. In his opinion, a mental health expert would have been able to testify to the petitioner's overall capacity and how he could be easily pressured in stressful situations, such as while being interviewed by aggressive police officers, without counsel. Upon further direct examination, so they must have been going back and forth, Mr. Chapman testified that the petitioner did not always appear to follow everything that was said to him, and at times did not seem like he was there. He further testified that the petitioner's school report indicated that this intellectual functioning was in the mild range of mental retardation. He said the petitioner was questioned for 12 to 13 hours before he gave his statement to the police. So, yeah. And the jury does not get to see what led up to this. The petitioner's trial counsel, who said he had been licensed to practice law since 1973 and had been in private practice, primarily criminal defense, since 1984, testified, so the trial counsel is testifying at this post-conviction proceeding, that the petitioner's case was the only one of hundreds he had handled in which he believed that an innocent man had been incarcerated. He stated he met with the petitioner on numerous occasions. during the course of his representation, and the petitioner was very easy to talk to and appeared to understand the charges against him. The petitioner could not, however, process the technical side of it in terms of the law, in terms of evidence. According to trial counsel, the petitioner's position was that he was not there and did not commit the crimes, and the petitioner could not understand why he'd been charged in the case. Trial counsel testified that they discussed having a mental evaluation performed on the petitioner and made an effort to contact someone for that purpose. However, the intervening development of Ms. Vance changing her story about the petitioner's participation in the crimes changed the course of their strategy in the case. He explained that there was no physical evidence linking the petitioner to the crimes, and that the petitioner became a suspect only after Ms. Vance implicated him in her statement to the police. When Ms. Vance confessed that she had been trying to protect her daughter and agreed to testify to that effect at trial, the issue of the petitioner's mental capacity became less important. So, explaining the shift in trial strategy. Her agreement to come and testify for the defense in this case kind of changed the course of the strategy that we were originally planning. And I think this is supposed to be a quote from trial counsel, that her agreement to come and testify for the defense in this case kind of changed the course of the strategy that we were originally planning. And Andrew's mental state, mental condition, ability were not seen as important in light of that new development with Miss Vance agreeing to come and testify. And what's interesting is if you have the defendant losing his cool on the stand, his own testimony, his decision to testify, you would think that this would, if you had this strategy before he took the stand, his performance on the stand, his agitation on the stand should have made you reconsider your strategy and say, well, maybe it's really important for us to call this witness, again, as Chapman explained above, to explain why he might be under different pressure when he's in the room with counsel versus when he's being interrogated for hours without counsel in front of police officers. But trial counsel testified that his original plan was to hire a confession expert, but he did not follow through with that plan in light of Ms. Vance's agreement to testify that her daughter was the perpetrator. In hindsight, however, he thought he made a mistake in not hiring the confession expert, who would have been able to explain to the jury why the petitioner would have confessed when he was not guilty. He stated that he extensively prepared the petitioner to testify, spending much time reviewing with him the length of the police interrogation and what led to his statement to the police, but that a confession expert could have helped the case tremendously, and that he erred by relying too heavily on Ms. Vance's testimony. In addition, trial counsel believed he erred by not instructing the petitioner to remain calm and refrain from becoming aggressive or argumentative with the prosecutor. Trial counsel testified that given the petitioner's limited mental capacity, he should have anticipated that the petitioner would become upset in the face of aggressive questioning and, quote, would explode under strenuous cross-examination. Trial counsel testified that he did not have the bloody fingerprints found at the crime scene tested because there was no evidence that the petitioner was at the crime scene and no evidence that the fingerprints belonged to him. So trial counsel could have said, hey, we tested the fingerprints and they're not my clients. So how is he the one bashing this guy and doing the murder, but it's not his fingerprints? The state should be finding who that person is. And then the state at trial probably would argue, well, just because someone else's fingerprint was bloody doesn't mean that they were the ones. Andrew could have still been the one that did it, but still, you give the jury the idea. As for his failure to exercise a peremptory challenge to strike juror number 7, who was an employee of the sheriff's department and a presumed co-worker of the victim's son, trial counsel, and they walk this same son, they say, hey, we found this card in a property. Do you know anything about this address? Yeah, it's my dad's. Well, could you come take a look? And they bring the son to the property where this guy is so poorly decomposed that the police officers are questioning how Andrew could have known that the guy was initially Caucasian. They bring the son there and they walk him into the house where there's like air fresheners on the floor, the scene of his decomposed father. They walk him there. They bring him there. And then his coworker's a juror. So not only is there a working relationship between a juror and the son of the victim, But the son of the victim was put in a very dramatic identification process. He was thrown into the crime scene environment where his father was horribly decomposed. Something that I would imagine you go back to work. How do you not talk to your coworkers about what you're going? How do you not get that off your chest? And again, it's not clear why they thought it was a good idea to just have him go walk into that scene. So trial counsel testified that he could not recall his reasoning, but the jurors' association with the sheriff's department would not have been an automatic basis for trial counsel to strike him. Counsel explained that he sometimes looked for jurors that he believed had the ability to process evidence and facts and make an intelligent decision, and that he would not have automatically assumed bias on the part of a juror because he was somehow affiliated with the sheriff's department and or working like alongside someone who went through traumatic exposure to his deceased father. On cross-examination, trial counsel testified that he never had any question about the petitioner's competency to stand trial. He also acknowledged that he filed an unsuccessful motion to suppress the petitioner's statement on the basis that the statement was coerced. Now, again, when we're getting back to these contrary things, this is an opinion, and I would imagine that stuff like this is they're pulling either on their own from the record, but they're likely pulling it from the state's reply in opposition to the brief filed by Andrew and his team. So this was probably an argument from the state. Well, he testified that there was no competency issue. Frances Wheeler, the owner of the rental home in which the petitioner had lived, testified that one morning she was at the property to work on the roof when Miss Vance and her daughter pulled up in a white truck with a television in the back. The petitioner, who was supposed to be helping her with the roofing, was asleep inside, but Miss Vance's daughter went in and then stuck her head out to announce he would be out in a minute. On cross-examination, Miss Wheeler testified that she was not sure of the date the events transpired. The petitioner testified that he was innocent and that he had faith in trial counsel to prove his innocence. On cross-examination, the petitioner acknowledged that he'd been a witness in another criminal case and that he understood his rights when the police interviewed him. He denied, however, that trial counsel prepared his trial testimony or kept him informed of the defense strategy in the case. On redirect examination, he testified that he was treated very differently by the police in the previous criminal case, in which he'd been merely a witness. Yeah, did they ask him for 27 hours about whatever happened in that case? He further testified that he only had an 8th grade education and that he spent his entire school career in resource classes. On October 5th, 2015, the post-conviction court entered a detailed written order denying the petition. On February 22nd, 2016, this court entered an order allowing the late filing of the petitioner's notice of appeal. And then so they do an analysis here. They end up finding that that they agree with the state. The state argues that the record supports the post-conviction court's finding that the petitioner received effective assistance of trial counsel. So they agree with the state's argument. And they note that the post-conviction petitioner bears the burden of proving his allegations by clear and convincing evidence. And they go through, first, that the counsel must show that the counsel's performance was deficient. The errors have to be so serious that the counsel was not functioning as the counsel guaranteed to the defendant by the Sixth Amendment. And then second, the defendant must show that the deficient performance prejudiced the defense. This requires showing that counsel's errors were so serious as to deprive the defendant of a fair trial, a trial whose result is reliable. So they say that the deficient performance prong of the test is satisfied by showing that counsel's acts or omissions were so serious as to fall below an objective standard of reasonableness under prevailing professional norms. So what do they say about this case? They find that the petitioner failed to meet his burden of demonstrating ineffective assistance of counsel. The post-conviction court, among other things, found that trial counsel made a sound strategic decision not to pursue a mental health examination in light of Ms. Vance's change in testimony, and the fact that there was no physical evidence linking the petitioner to the crime scene. The petitioner was not prejudiced by not having a mental evaluation. The untested bloody fingerprint did nothing to undermine the defense strategy of attempting to show that the petitioner was not at the crime scene. The petitioner failed to show that trial counsel was deficient for not striking the sheriff's department employee as a juror, or that he was prejudiced as a result of counsel's failure to do so. And the petitioner failed to show that he was prejudiced based on counsel's failure to call Ms. Wheeler as a witness. So And the record fully supports the findings and conclusion of the post-conviction court. Trial counsel, a very experienced criminal defense attorney, offered a reasonable explanation for why he did not pursue a mental health evaluation of the petitioner, explaining that there was nothing to link the petitioner to the crime scene other than Ms. Vance's statement to the police. Ms. Vance, however, later confessed to him that she had implicated the petitioner to protect her daughter, who was the real culprit, and she agreed to testify for the petitioner at trial. Now, isn't it something to read this while we know what's happening this month? That the real culprit, Steve Mulroy, we want to charge her. We're asking Oklahoma to extradite her. And yet we're reading this decision from 2017 denying Andrew's request for post-conviction relief. Although trial counsel believed in hindsight that a confession expert would have helped explain why the petitioner would confess to a crime he had not committed, he also testified that the petitioner was mentally competent to stand trial and that he was able to elicit details for the jury about the lengthy interrogation and the petitioner's emotional distress during questioning. As the post-conviction court noted, the petitioner also cannot show he was prejudiced by trial counsel's failure to have a mental evaluation performed. Trial counsel also offered a reasonable explanation for why he did not attempt to have the bloody fingerprints tested. So again, he said, there was no other physical evidence. They didn't think it was that important. What's something at the crime scene going to do if there's no evidence that my client was there at all? And then as for trial counsel's failure to call Ms. Wheeler as a witness, we agree with the post-conviction court that her testimony would not have altered the outcome of the trial. And that I think is the most, I think that's so strong. How do you have a flaw in the confession of one party? Now, we needed his help to move the TV, but he wasn't actually there to load the TV up. They just happened to have it in their truck when they pulled up to his house later. So, but the court's going to say, nope, not significant. It makes no difference. It matters not. So all that Miss Wheeler would have added to the case was that she had seen Miss Vance and her daughter arrive in a truck alone with a large television in the back. She was unable to testify as to the date the events transpired or how the television got into the back of the truck. In sum, the petitioner has failed to meet his burden of demonstrating that he was denied the effective assistance of trial counsel. So based on the foregoing authorities and reasoning, we conclude that the petitioner has not met his burden of showing that he was denied effective assistance of counsel. So they affirm the judgment of the post-conviction court. So that gets us all the way through this 2017 appeal. It started as a pro se petition. Actually, no, I lied. It started as a pro se petition. He gets counsel appointed. After this fails, he files a pro se habeas petition after this appeal fails. So in 2022, and I couldn't find this on the docket, but I was excited to see it was over on Case Mine. And I didn't want to pay to download it as a PDF. So I don't have this linked as like a Google Doc upload, but I have the link included in that gamma. Let's take a look here. Let's see. It's kind of annoying to read this way, but we'll make it work. I'll move my picture over and make this side bigger. Aha! There we go. I like that. All right, so Andrew Hayes is the petitioner here against the warden where he's being held. So remember, a habeas petition, like, you don't have a right to hold me. Something's wrong here. So you'll often see the warden as the defendant in a habeas petition. So we've got here an order to update the docket with the current respondent, granting motion to expand the record, dismissing the habeas petition, denying a certificate of appealability, certifying appeal not taken in good faith, and denying leave to proceed in forma pauperis. What does that mean? Let's look that one up. That's new to me. What are we learning today? Let's see if I can Google faster than Aaron will answer us in the chat. So we've got informer pauperis is a Latin legal term meaning in the manner of a pauper. Okay. It allows individuals who cannot afford to pay court fees, so if you're pro se, to file a lawsuit without the financial burden of those costs. They don't have to pay the filing fees. So there we go. It gives them access to bring this type of petition forward. All right, so let's get back to reading over here. Yeah, and in shorter words, indigency status. I can say indigent, but indigency is a weird word. I'm going to say that 10 times fast later. All right, so we've got petitioner Andrew Hayes petition pro se. Respondent answered the petition and filed the state court record. So it seems like Andrew Hayes wasn't able to supply the record of the previous proceedings of the trial. So the state was asked to do so, and so they did. Or I guess the warden here, but the issues in this habeas petition fall into two categories: whether the procedural default doctrine bars his claims, and two, whether the state court identified and applied the correct federal legal principles. And then for the reasons discussed below, the court finds that the procedural default doctrine bars one of petitioner's claims and that the state court correctly applied federal law to the other. So this ultimately gets denied and dismissed. Let's see. You can't proceed. And I don't know if this procedural background is going to go over a lot of the dates that we looked at. It's talking about the post-conviction proceedings that we just heard about in the prior opinion. And let's see. Typically, the trial judge also hears post-conviction claims. The trial judge here, however, moved to recuse herself and then granted that motion. So a different judge heard the post-conviction proceedings that we just read about. In the motion to recuse, the trial judge noted that it received a letter after the trial from the chief investigator alleging the innocence of the defendant and new evidence which may or may not involve alleged misconduct by the defendant's original attorney and members of the Shelby County Sheriff Department. And so the trial judge found that the letter created a perception of possible bias on the judge's part, and that would be prejudicial to the defendant. So that's interesting context. Let's see. It said the motion referred to the letter and said it was attached as Exhibit A. I don't have that, I'm sorry. But the letter the trial judge referenced was missing from the record here. Okay, so we don't have it here either. So that's the only context we're going to know about this letter. When this court asked whether the record here is complete, respondent, so the warden, said that he was unsure why the state criminal court clerk's office failed to include the exhibit in the record. Respondent noted that it was the duty of the appellant to prepare a record which conveys a fair, accurate, and complete account of what transpired with respect to the issues which form the basis of the appeal. So, respondent says, hey, we tried to get this record over to you. I don't know why the clerk didn't approve it, and it's not our burden, even though we're doing it here because of, Andrew Hayes is indigent here. So the pauper thing. The court then appointed counsel for petitioner to assist in determining what happened to the exhibit. So he filed pro se, but now he has counsel to help him with this issue. Find out what the exhibit said and whether petitioner's counsel had access to the exhibit during the post-conviction proceedings. During this process, respondent sent a formal document request to the Shelby County District Attorney General's office, and the district attorney's officer, quote, had and provided the letter to respondent. Respondent has filed the letter provided by the district attorney's office as an exhibit here. Do we have that? All right, so we're like here. Let's keep that highlighted. No, it looks like it just goes to the order at the bottom. And unfortunately, I'm relying on CaseMind for this. I didn't, unless, I think maybe I was looking stuff up wrong, but I wasn't able to go and pull up this filing from the court. All right, so where were we? So petitioner's appointed counsel reviewed the original state court jacket and spoke with the Shelby County Criminal Court Clerk's office. Counsel discovered that the missing exhibit was in a sealed envelope in the jacket, and the staff had overlooked it and did not properly handle it when compiling the record here. Well, what about everything else? Petitioner's counsel noted that the exhibit had not been properly attached to the state court motion until she brought the envelope, an exhibit to the criminal court clerk's attention, and requested that the letter be attached. The state court record thus was incomplete when respondent filed the record. Again, not due to the fault of the respondent here. Petitioner's counsel also spoke to Petitioner's post-conviction attorney, who advised he was only aware of the exhibit after speaking with defense investigator Clark Chapman before the post-conviction hearing. Post-conviction counsel had not learned of the trial judge's recusal and had not received a copy of the letter. Petitioner's counsel has moved to expand the record here to include the exhibit for this court's review. Respondent has no objection, so that motion is granted. Having had a chance to review the letter, this court is now satisfied that Petitioner's post-conviction attorney was aware of the defense investigator's allegation at the time. In fact, that counsel called the investigator as a witness during the post-conviction hearing and explored the investigator's concern in that letter. No evidentiary hearing will therefore be required for the court's resolution of the issue raised by Petitioner in this federal habeas proceeding. So nothing new was already addressed at a different proceeding. And then they're going to go through the evidence, right? So they're going through the summary of what was presented at trial. We have the testimony from Snow. And Snow said at trial he has a nervous condition. He was dating my daughter. He helped pay the rent with his disability proceeds. He did a little work on the side for a neighborhood grocer. Snow testified that toward the end of August 2007, Sarah Lucas and her boyfriend, a Hispanic man named Miguel, moved into the DePass Street residence because Miss Jefferson and the defendant were preparing to move out. So that's why they're all just piled together. Tammy Vance, Sarah Lucas's mother, also moved in for a brief time, telling Snow that she needed a place to stay while her boyfriend was in rehab. Boyfriend is Danny Harris. And then this is where we have the black eye story. Let's see. Miss Jefferson and the defendant did not move as planned, but continued to live in the house along with Miss Vance, Miss Lucas, and Miguel. In October, Snow asked Miss Lucas, Miss Vance, and Miguel to move out of the house because they couldn't pay on the utility bill. So you got all these people living there and they're not paying. So Miss Vance, so Tammy, Sarah, and Miguel are not contributing and they're asked to move out. Snow said that Miss Vance was the first to leave the residence, but before she left, Miss Vance offered to compensate Snow with some groceries and some Ice House beer. We got some beer. Later, Miss Vance brought in a TV that she claimed had been given to her by a lady around the corner. So that's Tammy Vance's story about where this TV is coming from. Finally, Miss Vance brought in a handgun and offered it as payment to Snow. Later, she asked Snow to help her sell the gun as well as the victim's truck, telling Snow that the victim was going to be in rehab longer than she thought, and he told her to go sell the gun and get her some food and stuff. Snow acknowledged that she directed Miss Vance to Wheelchair John to sell the gun. So there's a guy named Wheelchair John entering the chat now. Snow testified at that point that she became concerned about Miss Vance selling the victim's possessions, so she telephoned the police. On Halloween, Snow met police officers at a nearby Mapco convenience store, where they had Miss Vance surrounded in the victim's truck. She led officers to the DePass Street residence and told them about the items Miss Vance had given in exchange for rent. Snow testified that she granted officers permission to search the residence. Snow testified during cross-examination that she never saw the defendant in possession of any item belonging to the victim, and that she had no personal knowledge of the defendant's being involved in the victim's murder. She said that as far as she knew, the defendant had no relationship with either Miss Vance or Miss Lucas and had not met them prior to the women's moving into the DePass Street residence. Snow testified that on Halloween, she was driven to the police station to give a statement, and the defendant followed in a borrowed car to give her a ride back home. So this is how Andrew ends up in the situation where he's going to be questioned by police. Snow rides with somebody, maybe an officer, to go give a statement. And Andrew's just following behind, like, when you're done, I'll drive you home, since you're riding with somebody else. She said that they left at approximately 7 that evening, and that officers returned to her residence on November 2nd, and that's when they kept the defendant. So they end up dropping her back home and keeping Andrew, even though he drove there to drive her home. On November 2nd, she returned to the police station during the early morning hours at the request of homicide detectives, and when she arrived, the defendant screamed out to her, "I love you, Mama, take care of my baby." Snow said that the police told her that the defendant had implicated her in the victim's murder, and she asked the defendant why he had lied. Sarah Lucas testified that in August 2007, she moved from her Cecilia Street residence to Snow's DePass Street residence because she did not like the living conditions at the Cecilia Street residence. She said that she knew the defendant only as Snow's son-in-law, and that the victim was a man that her mother lived with. She described the victim as a very, very nice man. Miss Lucas testified that sometime in the beginning of August, her mother, Tammy Vance, came to her Cecilia Street residence bleeding from a cut on her head. She said that Miss Vance, who was driving the victim's truck, told her that the victim had struck her and that he had decided to enter rehab because he was drinking too much and smoking too much cigarettes. She said that she and her mother moved in with Snow about 2 weeks later. Miss Lucas recalled that Miss Vance gave Miss Lucas's boyfriend a DVD/TV type deal for his birthday, and that she did not believe the item belonged to Miss Vance. She said that Miss Vance also brought a big, huge TV to Snow residence in the back of the victim's truck. So all of this, even though they're wording it this way for the filing, Sarah Lucas talking about her mom, Tammy Vance. Miss Lucas testified, so Sarah testified that she first learned of the victim's death when police arrived to take her in for questioning. She said, so obviously she didn't do it. I didn't know he was dead. She said police told her that the victim had been murdered inside his apartment. She said that police took her in for questioning because she pawned a DVD VCR that belonged to the victim. She testified that she pawned the item at her mother's behest, and that Miss Vance told her that the victim had given his permission for the item to be pawned. She said she knew nothing about the victim's murder. During cross-examination, Miss Lucas testified that she came to testify at trial because Miss Vance had implicated her in the victim's murder, saying that she wanted to clear her name and to get justice for the victim. She said that Miss Vance, so her own mom Tammy, had implicated her in the victim's murder because she's crazy. She acknowledged that Miss Vance was in prison for the victim's murder. Miss Lucas said that she had no knowledge of the defendants playing any role in the victim's murder. Miss Lucas conceded that the prosecutor had cleared up the outstanding warrants for drug possession and prostitution that she had when she moved to Texas in 2008. So, right before she gives her trial testimony, she's got a bunch of warrants. She gives her testimony. Those are all null pros. They go away. They're dropped. It all goes away, and she moves out of state after delivering her testimony. She admitted that she went to Arkansas to obtain an identification card, but denied that she went with the victim and Miss Vance to do so. And at trial attorney did not confront Sarah Lucas with the identification card, with the phone records that detail, the devices that went along for this trip and then go back to Danny Harris's house later that same day and whose devices were still along for the whole ride. Jury doesn't see Sarah confronted on these issues in the discovery file. Let's see. Miss Lucas said that Miss Vance, so her mom, asked to stay with her in August 2007 because she didn't want to stay by herself across town. To her knowledge, Miss Vance and the defendant did not have any type of personal relationship. Leslie Kennard, an employee at Woodchase Apartments in 2007, testified that in September of that year, she was directed to verify that the victim was still living in his apartment because the rent had not been paid. So this is the other landlord. There we go. Miss Kennard said that she knocked on the door, and when she got no answer, she peeped inside the door and saw that the furniture was still in the apartment. She said that after the victim failed to pay his rent by the 15th of October, the victim was scheduled for a set-out at the end of the month. Ms. Kennard said that after following the appropriate legal procedure to evict the victim, she went to the victim's apartment with 2 sheriff's deputies and the property manager. The deputies entered the apartment first, and they came out and told Ms. Kennard that the victim was deceased inside the apartment. Shelby County Sheriff's Department Deputy Stanley Gibson testified that he went to the victim's apartment to assist with an eviction on October 26, 2007. When he entered the apartment, he noticed that the bedroom door was shut and that a towel or sheet had been placed at the bottom of the door. He and his partner popped the door open and observed a body lying in bed and smelled a strong odor. Deputy Gibson said that upon seeing the body, they left the apartment, secured the door behind them, and contacted their supervisors. Memphis Police Department MPD Officer Milton Gonzalez testified that on October 31st, 2007, his office received a call that the victim's vehicle had been spotted in the Jackson-Orkai area of Memphis. As he went to that location, he saw the vehicle being driven by a white female. When the vehicle turned into the MAPCO station, Officer Gonzalez initiated a traffic stop. So remember, this is that same Halloween we're hearing about earlier, where her car's surrounded. The driver identified herself as Tammy and told officers that she was the victim's girlfriend. The vehicle was towed to the police station, and the driver was placed under arrest. MPD officer John Paisley testified that the victim's truck was seized and Ms. Vance arrested at the Mapco station. He said that as the officers waited for homicide detectives to arrive, Snow and Miss Jefferson approached him and said that they knew something about the case and that Miss Vance had left some items in their home that they thought police might be interested in. He followed the women to their residence, where Snow showed him a TV, a cell phone, and a little notebook journal that she believed had belonged to the victim. Officer Paisley said that he then telephoned homicide detectives, who told him to call the crime scene unit to photograph and collect the items. Officer Paisley testified that he drove Snow and Miss Jefferson to the police station, and that the defendant followed, driving in a separate vehicle. He then went to pick up Miss Lucas, her boyfriend, and Wayne Bobo. Unable to locate Mr. Bobo, he transported Miss Lucas and her boyfriend to the police station. And then we have, this seems like it's being quoted from somewhere. Because all the other witnesses referred to Janice Jefferson as Snow during their testimony, and because both Janice Jefferson and Shawana Jefferson testified at trial, this court will call the witness Snow to avoid confusion. So, on the following day, he and Sergeant Autry's fake accent says that Sarah was gone like a fart in the wind. Yeah, after all of those charges are cleared. After her testimony. So, on the following day, he and Sergeant Nelson met with John Watkins, who was known as Big John, or maybe also known as Wheelchair John? Big Wheelchair John? Wheelchair Big John? And who was confined to a wheelchair. Based on information they had that the victim's handgun had been sold to Big John. They recovered the victim's weapon from Big John. So, ATF agent Richard Howard testified that the Sig Sauer .40 caliber handgun recovered by Officer Paisley had been purchased by the victim on October 31st, 2000. MPD crime scene investigator Jeffrey Allen Gary testified that when he arrived at the victim's apartment, the victim was lying on his back, on a bed. His left leg was hanging off the left side of the bed, foot touching the floor. The body was in a severe state of decomposition. There were flies throughout, maggots all over the body and the bedding. Investigator Gary testified that he collected a SIG Arms gun box, a piece of mail postmarked August 14th, 2007, a partial loaf of bread that bore an expiration date of August 17th, bloody sheetrock and paint samples, 3 rings from the dresser, an instruction manual for a Hitachi DVD player with video cassette recorder, and the sheets, pillows, and pillowcases from the bed where the victim's body was discovered. He photographed an unidentified light spot with other lighter speckled spots on the carpet in the bedroom. Quote, possible blood spatter on the south wall of the living room, a corner of the wall area that appeared to have a blood print, a door jamf, a door jamb, I guess, where a possible bloody print was located, and blood spatter on 2 separate walls in the bedroom. MPD Lieutenant Bart Ragland testified that Lieutenant Mason, who was the lead investigator, asked him and Sergeant Parks to go out and pick up Miss Vance, Snow, and Miss Jefferson, and the defendant. He said they were not suspects and that they drove to the police station in their own car. Lieutenant Ragland testified that he and Sergeant Parks interviewed the defendant, who they believed had relevant information because of his involvement with Tammy Vance and her daughter. During that first interview, the defendant's story kept changing and changing and changing. Lieutenant Ragland said at that point it became obvious that he knew more than he was telling, and that he had more involvement than just being a witness, so they provided him with Miranda warnings. And this is stuff we heard from the previous opinions. The defendant had some difficulty reading the advice of rights form. The defendant had the difficulty. Ragland read the entire thing to him, and he understood and went over it. And we heard that he executed a written waiver of his rights. And provides a statement that same day implicating Miss Vance in the victim's murder, telling officers that he traveled with Miss Vance and Miss Lucas's boyfriend Miguel to an apartment in Cordova to get a 36-inch television. So, again, he's saying in his statement he went to go get the TV. The defendant told officers that he opened a closed bedroom door inside the apartment because he smelled the foul odor and saw the victim's body laying in the bed. He said Miss Vance told him not to worry about the body because she and Miguel were going to take care of it. The defendant described the body as a white male. He was laying on his left side. He was about in his mid-50s. He was medium build. His skin was turning black. His hair was brown, and he had a mustache too. He said that he did not notice anything in the victim's mouth or any blood in the room. He said that he and Miguel loaded the TV into the victim's truck, and that Ms. Vance also removed a VCR and a DVD player that was built together and DVD movies. He said that they left the victim's apartment and traveled back to the DePass Street residence to pick up Miss Lucas so that Miss Lucas could pawn the items. The defendant told Lieutenant Ragland that he did not tell anyone about seeing the corpse in the apartment because he was afraid that he would be charged with the victim's murder because he'd helped move the television. So, again, we read a lot of this previously, so it's still going to go over, the trial testimony. Ragland said it's suspicious that he was able to identify the decedent as a white male. Admitted to hitting him with the pipe. They held him for the 48 hours. So again, if you're jumping into this late, we did read these same paragraphs from different motions. All right, let's go forward. All right, so Dr. Marco Ross, the forensic pathologist who performed the victim's autopsy. Let's make sure we didn't miss anything, actually. Let's go backwards. All right, so let's go to Sergeant Mullins. We're going to skip the Ragland stuff. So Sergeant Mullins testified that officers brought the defendant to the homicide office for another interview on the following morning. The defendant provided a statement admitting that he murdered the victim by striking him with the metal pipe about 7 to 8 times to the head. He said that he went to the victim's apartment to rob him. Tammy said to ride with her to rob her boyfriend. And then the defendant admitted, I struck him the first time with the pipe. She grabbed the victim by the mouth and shoved a face towel in his mouth. So now he's aware of the face towel in this part of the statement. And the defendant said he did not get blood on him and that Miss Vance threw the murder weapon into the Wolf River. All right, so this is new here, I think. Sergeant Mullins testified that he'd been trained in basic bloodstain pattern analysis, which he described as locating, analyzing, and documenting bloodstain patterns on crime scenes, and then interpreting that evidence to determine what can be determined. He said that victim location, assailant location, and how the crime occurred could be determined by analyzing bloodstain patterns. Sergeant Mullins testified that he had been at the crime scene on a single occasion for a matter of hours, and that the defendant's statements was corroborated by what Sergeant Mullins had seen, what he'd seen at the crime scene previously. He noted cast-off bloodstains on the walls in the bedroom, which he described as coming as a result of the blows to the victim. He said, once a blow is given and blood is transferred from him to the instrument, every swing is going to cast blood off that object. And in this case, a lot of it hits the surface of the wall. Sergeant Mullins also identified blood cast off on the floor and the closet door. Sergeant Mullins testified that based upon the 6 distinct patterns of blood stain, it appeared that the victim had been hit at least 6 to 8 times. He said that a hard shove would have sent the victim from the doorway of the bedroom onto the bed. Dr. Marco Ross, the forensic pathologist who performed the victim's autopsy, testified that the cause of the victim's death was blunt force injuries of the head and asphyxia. Dr. Ross testified that the victim suffered fractures of the skull in the right frontal area and the left frontal area, as well as some fractures involving the bones around the orbit of the right eye and the face, and a little bit on the right cheek, and the roof of the orbit on the right eye. In addition, the victim had a fracture of the left upper canine tooth, which Dr. Ross found in the airway of the right lung. So they beat him so badly, he inhaled a tooth, part of a tooth. Ew. So they find this in the airway of the right lung, probably in the region of the right main stem bronchus. Dr. Ross identified some hemorrhage or material consistent with hemorrhage in the brain itself, although due to the decomposed nature of the brain, it was difficult to precisely delineate where that hemorrhage may have originally come from. Dr. Ross noted that the victim was in a moderately advanced stage of decomposition. Dr. Ross said that the victim had an orange towel that was stuffed into his mouth, and that the towel pushed the victim's tongue back and effectively blocked the victim's airway. So that's how he ended up dying of asphyxiation. The location of the tooth in the bronchial tubes indicated that the tooth was knocked out before the rag was stuffed into the victim's mouth. Dr. Ross testified that the victim suffered a total of 8 lacerations to the head area, and that based upon the locations of the lacerations on the head, and given the configurations of the head and face, a minimum of 5 separate impacts to the head and face were sustained. He explained that his findings indicated that the victim suffered a minimum of 5 and a maximum of 8 blows to the head. Toxicology testing detected the presence of ethanol at a level of 199 milligrams per deciliter, which on the breathalyzer scale is similar to a 0.19. But Dr. Ross cautioned that alcohol typically forms as a result of the decomposition process. So we can't just conclude that was his blood alcohol content at the time of death, because we can't, there's a diminishing ability to detect accurately what the composition might have been at the time of death. Dr. Ross removed the victim's pacemaker device during the autopsy. Joel Hunt, an employee in the pacing division of Boston Scientific, testified that he was charged with programming and troubleshooting implantable pacemakers and defibrillators. Mr. Hunt identified the device removed from the victim as a dual chamber, meaning it can pace and defibrillate the top chamber and the bottom chamber of the heart. By examining the data he removed via computer from the victim's pacemaker, Mr. Hunt learned that on August 20th, 2007, the victim's heart rate accelerated to 205 beats per minute, activating the pacemaker, which regulated the heart rate. The victim's heart then accelerated to 289 beats per minute, which activated the defibrillator. The defibrillator delivered 2 shocks, and then from that point on, nothing else is detected or sensed. On October 27, 2007, the pacemaker delivered shocks, which would have been attributed to the autopsy. Although he could not say when the victim died, Mr. Hunt could say that all heart activity ceased on August 20th, 2007. Yeah, bloodstain pattern evidence. Where did I hear about that? All right, so Learned Hand Knits is saying Fairfax County is probably shut down for the whole week. And when we can't melt ice and precipitation is super high, and yeah, things get shut down for a while. I still have this open. Let me refresh it. They have closed all county government offices and all courts for Tuesday. So for things like the Banfield trial, no court tomorrow, Tuesday, for that. And we might end up having to do this stream in 2 parts because I want to read the new Coram Nobis petition. And depending on how my voice holds out as we finish reading through this, you know, this might become 2 parts. I'll try to make it 1, but it might become 2 parts. So since there's no court tomorrow for Brendan Banfield, I mean, would you guys be okay if we do a part 2 on this tomorrow? I think that'll keep this concise for everyone watching live with me and going over this. And I also like the idea, I don't want anybody on replay crew, if they want to watch the second part, to have to go look at my video timelines like months apart, weeks apart, days apart to find out where the next update is. So I think tomorrow could be, if we pause, we could do more of this tomorrow. So, all right, Trikisha's on board. There we go. Dizzy says perfect. So that'll be, because it's already 3 p.m. my time. And I do want to watch the oral arguments for the appeal, which comes before the current Coram Nobis petition. So that'll probably take us, will probably be like 4:35 before we finish those 2 items. I don't know if I want to go past 5 for my voice. You guys got to kick me off of here at 5 or I'm going to lose my vocal cords. So we've got, let's see. All right, wait. So following Mr. Hunt's testimony, the state rested. Dr. Randy Schnell, clinical service coordinators of the Memphis. All right, so this is where we get information about the testimony about the IQ. Let's see. 21-year-old Shawana Jefferson testified that she and the defendant dated for several years and had a 3-year-old child together. And I think he's 17 now. Maybe he's about 18. But he's in, if you guys want to go hear from him, he's included in the final episode of the podcast, so episode 6. And then he's also done, I think, 2 different interviews with Stephanie Tinsley with other news agencies. And those videos are included in the playlist in the description of this video. So if you want to go and check those out and hear from Andrew Hayes' son, obviously at the time of trial, he was 3 years old. He was 3 years old when Shawana testifies. And now he's 17, 18. So she said that at the time of the victim's death, she and the defendant lived with her mother, Snow. I'm going to stop highlighting because it keeps popping up this little box. Miss Jefferson said that Miss Vance and Miss Lucas, so Tammy and Sarah, came to live with her in the home in late August 2007, and that at that time the women were driving a Silverado truck. It's always a Silverado. She recalled that Ms. Vance had a bruise on her head and a black eye. The 29-year-old defendant testified, so this is him on the stand, this is Andrew on the stand. He had never met the victim. The defendant said that he only went as far as the 7th grade and that he'd taken only resource classes. He testified that his only source of income at the time of the victim's murder was a Social Security disability check of $685 per month. He said that he worked at a neighborhood store, sweeping the floor and stocking shelves in exchange for Pampers and milk to provide for the child he'd had with Miss Jefferson. The defendant recalled that he first met Miss Vance when she and Miss Lucas moved into the residence owned by Snow. At that time, the women were traveling in the victim's truck. He said that Miss Vance had a gash in the center of her forehead, so Tammy had a gash in the center of her forehead and her eye was black. The defendant testified that on November 2nd, 2007, officers returned to the DePass Street residence and asked him, Miss Jefferson, and Snow to return to the police station for questioning. He said that they traveled to the police station together in the family vehicle. The defendant claimed that after he had waited alone in an interview room for several hours, Lieutenant Ragland told him that Miss Vance had implicated him in the victim's murder. He said that he told them that he had no part in the victim's death. The defendant testified that although he initially denied any knowledge of Miss Vance's possession of the victim's handgun, he eventually told officers that he'd gone with Miss Vance and Snow to sell the gun to Big Wheelchair John. He said that the initial interrogation lasted hours and that he got tired of sitting there. He claimed that the officers continued to scream at him for hours until he finally said, "What the P*** do you want to hear? And what do you want me to tell you?" He said that at that point, the officers created a statement that was allegedly given by him. The defendant testified that although he had no knowledge whether Miss Vance had killed the victim, he told the officers that she'd probably killed the victim because she had accused him of doing so. He said that when he was in the office, the officers showed him a live feed of Miss Vance's interrogation and told him that she was accusing him of the murder. The defendant admitted accusing a number of others, including Snow, of being involved in the murder, just so they would leave him alone. During cross-examination, the defendant said that he had never given a statement in a criminal case prior to this one, and that he had never testified in court. The defendant admitted that he had tattoos of a pitchfork and folk, which were associated with the gangster disciples. Oh my gosh, we've gotten everything on the bingo card now. Chat, we've gotten everything on the bingo card. We have blood spatter. We've got a false confession. We've got a different culprit. We've got a dating hotline. And now we have enter the gang tattoos. We've got everything. We have the full bingo card. So the defendant questioned the state's evidence, saying, "The only evidence you all got against me is what Tammy said and that bogus statement that I gave. That's all you got. The detective just admitted it yesterday. If I wouldn't have said I had nothing to do with killing Mr. Danny Harris, I wouldn't be sitting here today. By me being stupid and constantly just allowing them to just drill me the way they did, if I would have just left it alone and let them deal with their job, I wouldn't be sitting here today. You know it and I know it." The defendant insisted that he did not commit the crime, claiming that his statement contained only the repeated details about the crime that detectives had provided to him. Tammy Vance testified that she pleaded guilty to first-degree murder and aggravated robbery related to the victim's death. She nevertheless denied having killed the victim, whom she said she'd met through a chat line in January of 2007. Dang, so from January to August 2007, this man's life goes to hell and ultimately ends. That's all it takes. Ms. Vance testified that she lived with the victim for about 2.5 months, and that during that time, the victim was not in good health because all he did was drink beer and smoke cigarettes. She said that the victim gave her free access to his trucks and personal finances, which came primarily from retirement benefits, so that she could manage his personal affairs. Ms. Vance claimed that the victim intended to file for bankruptcy because he could not make ends meet. Ms. Vance testified that on August 20th, 2007, she and the victim woke early to take Sarah to West Memphis to procure an identification card. She said that Miss Lucas was addicted to crack cocaine and that the victim kind of felt for her because he had an addiction. After concluding their business, the three went to Burger King, not McDonald's, where the victim purchased food from Miss Lucas. Miss Vance said that when she told the cashier to go ahead and keep the change for somebody else, the victim became very irate and started beating his fist on the dashboard, slapping his hat. Despite the victim's outburst, they returned to the victim's apartment, and she prepared a fried egg sandwich for the victim's lunch. She testified that as the victim ate, he put the sandwich down, and he got up and balled up his fist, and he hit me on my head and split my head wide open, and I was dazed. I fell to my knees to the floor. She said that when she came to, she found the victim and Miss Lucas in the victim's bedroom. Miss Vance claimed that Miss Lucas had hit him with a hammer in the head, and he was laid back on the bed. She said that she tried to stop Miss Lucas, but Miss Lucas struck the victim a couple of times, and then struck Miss Vance one time. All right, so she hits her mom too, according to Tammy. According to Miss Vance, Miss Lucas struck the victim a total of 7 or 8 times. Then when she got through with that, she took a rag and put it down his mouth. Miss Vance testified that Miss Lucas's violent attack on the victim caused her to be in total shock and that she did not know what to do. She watched as Miss Lucas poured kerosene and some cleaning substances over the victim's body. It's just crazy. Like, we're going from... So you have Sarah, like if we track this story, they're on a trip to help Sarah. They're on a trip to help her get an identification card. She's dealing with an addiction. Tammy and Danny are dealing with money issues, where Danny's like, I might file for bankruptcy. So they stop at a Burger King and only get food for Sarah because it seems like they want to save money. So they purchase food for Sarah, but then Tammy prepares food at home for Danny. And then Danny may have been upset, and maybe this actually happened that way, where Danny is upset about, like, why are you letting this cashier keep the change when you know we're tight on money? Like, we're already spending money to get Sarah Burger King instead of eating what's already at the house. So this all ensues. And then all of a sudden, Sarah, she's murdering somebody and has the idea to try to hide the crime scene. Like, if this is how this played out, that's cold-blooded. That is cold-blooded. So Miss Vance said that she complied with Miss Lucas's command to pack her things. So Tammy says, I'm listening to my daughter's commands to pack her things, and that the 2 women left the victim's apartment in the victim's truck. Miss Vance claimed that Miss Lucas put the murder weapon in her bag and later disposed of it in a dumpster near a convalescent home. The 2 women returned to the victim's apartment several days later to get a television and other items to pawn for money. She first met the defendant on that day. She said that she and Miss Lucas had decided to blame the victim's murder on Wayne Bobo, and that she initially did so when questioned by police. She testified that after police told her that the defendant had confessed, she blamed the defendant for the murder in order to protect Sarah, her daughter. She said that not a bit of her statements incriminating the defendant was true. Miss Vance claimed that after she was charged with the victim's murder, she tried to tell her lawyer that Miss Lucas had committed the murder. Despite her innocence, she decided to plead guilty. She said that just prior to entering her pleas, she wrote a statement exonerating the defendant and asked her attorney to give it to defense counsel. During cross-examination, Miss Vance acknowledged that she continued to cash the victim's checks. Based on this evidence, the jury convicted Andrew as charged of felony murder and aggravated robbery. The trial court imposed an automatic sentence of life with the possibility of parole for the murder conviction, and following a sentencing hearing, a concurrent sentence of 20 years for the aggravated robbery conviction. Following the denial of his timely but unsuccessful motion for a new trial, the defendant filed a timely notice of appeal. In his appeal, the defendant contends that the trial court erred by denying his motion to suppress the incriminating statements he provided to police, that the trial court erred by admitting into evidence 6 photographs depicting the deceased victim, and that the evidence adduced at trial was insufficient to support his convictions, and that the trial court committed plain error in its instruction to the jury. And then they consider each claim in turn. So they go through these issues, you guys. So we've got evidence at the post-conviction hearing. So I think this is what we read about. We have Clark Chapman, the private investigator, his testimony at the post-conviction hearing. Cross-examination. Chapman testifies that he spoke with the petitioner and that he appeared to be engaged. So this is everything we just read in the previous document. On redirect, he explains that Miss Wheeler's testimony that the 2 women brought the television to the house alone was significant because the state's theory at trial was that Miss Vance had to have the petitioner's help in loading the television. And then on recross, Chapman acknowledges that the petitioner provided details in his statement to police that were consistent with the physical evidence at the crime scene. And this whole statement, like, yes, the defendant himself at trial told the prosecutor while on the stand that you're not going to make me say anything I don't want to say. So we went over all of this. Trial counsel was competent. It was working in criminal defense for decades. The trial counsel regretted not having someone perform a mental evaluation. Let's see. Why he changed his decision on hiring a confession expert. Let's see. Why he didn't have the bloody fingerprints tested. Never had an issue with his competency to stand trial. And then ultimately, as we know, the post-conviction court entered a detailed written order denying the petition that we just read. All right, the habeas claims. So petitioner now claims that trial counsel provided ineffective assistance in several ways. First, he claims that counsel should have conducted a mental evaluation of the petitioner. He argues that counsel was ineffective for not calling Miss Wheeler and for not striking someone from the jury. He also argues that counsel should have compared the fingerprints at the crime scene against the fingerprints of Sarah Lucas. And finally, that counsel should have objected to the trial court's jury instructions. Further, he argues that the trial court violated his due process rights by denying his motion to suppress his statements to the police. So, legal standards. Let's see. Exhaustion of procedural default. So, Tennessee gave him these other procedures. Much like the exhaustion requirement, the procedural default doctrine applies to habeas petitions from state prisoners. So we're going to skip through some of this, but it is linked if you want to read it in full. Let's see. And then the merits. So under Section 2254D, where a state court decided a claim on the merits, a federal court should only grant a habeas petition if the state court's decision, 1, was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, or 2, was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. So petitioner carries the burden of proof on this difficult to meet, not good language, you've got a high mountain. So difficult to meet and highly deferential AEDPA standard, which demands that state court decisions be given the benefit of the doubt. So we're not just going to willy-nilly overturn a decision that a state court has made. There's a high burden that has to be met. The court must limit its review to the record that the state court used to adjudicate the claim on the merits. A state court's decision is contrary to federal law, and this is why we had to deal with the issue of the missing letter, I guess. When a state's court decision is contrary to federal law, when it arrives at a conclusion opposite to that reached by the Supreme Court on a question of law, so an error of law, or decides a case differently than the Supreme Court has on a set of materially indistinguishable facts. A state court makes an unreasonable application of federal law when it identifies the correct governing legal principle from the Supreme Court's decision, but unreasonably applies that principle to the facts of the prisoner's case. So the state court's application of clearly established federal law must be objectively unreasonable for the writ to issue. And the habeas court may not issue the writ just because, in its independent judgment, it determines that the state court decision applied clearly established federal law erroneously or incorrectly. Yeah, so very, very small window to be successful on this type of thing. There's little case law addressing whether, under 2254D2, a state court based its decision on an unreasonable determination of the facts. In Wood v. Allen, but not Woody Allen, the Supreme Court noted that a state court factual determination is not unreasonable only because the federal habeas court would have reached a different conclusion. And in Rice v. Collins, the court explained that reasonable minds reviewing the record might disagree about the factual finding in question, but on habeas review, that does not suffice to supersede the trial court's determination. So we can't just look at the facts differently. So the Sixth Circuit has described Section 2254D2 standard as demanding but not insatiable, and has emphasized that the federal court presumes the state court's factual determination is correct, absent clear and convincing evidence to the contrary. A federal court will not overturn a state court adjudication on factual grounds unless it is objectively unreasonable given the evidence presented during the state court proceeding. So here, let's see, we're going back to Strickland, Adventure Aaron's favorite case. So ineffective assistance of counsel. The standards from Strickland v. Washington control a claim that ineffective assistance of counsel deprived a defendant of a Sixth Amendment right to counsel. To succeed on this claim, a movement must show two elements: that counsel's performance was deficient and that the deficient performance prejudiced the defendant. The benchmark for, and remember, this court is considering the lower court's decision to deny the petitioner's claim under the Strickland standard. So this court here is deciding, well, for the sake of this habeas petition, was the court objectively unreasonable? The benchmark for judging any claim of ineffectiveness must be whether counsel's conduct so undermined the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. So, cannot. Like, every single possibility of producing a just result has to be eliminated. That's the benchmark. That is a high benchmark. To establish deficient performance, a person challenging a conviction must show that counsel's representation fell below an objective standard of reasonableness. A court considering a claim of ineffective assistance must apply a strong presumption that counsel's representation was within the wide range of reasonable professional assistance. The challenger's burden is to show that counsel made errors so serious that counsel was not functioning as the counsel guaranteed the defendant by the Sixth Amendment. To show prejudice, a petitioner must show a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome, and it is not enough for the defendant to show that the errors had some conceivable effect on the outcome of the proceeding. Instead, counsel's errors must be so serious as to deprive the defendant of a fair trial, a trial whose result is unreliable. Let's see. And we have Wong v. Belmontes stating that Strickland does not require the state to rule out a more favorable outcome to prevail, but places the burden on the defendant, not the state, to show a reasonable probability that the result would have been different. And then if reviewing court finds a lack of prejudice, it need not determine whether, in fact, counsel performed deficiently. So, even if you were to, it has to be both standards. Not only was there deficient performance, but did it prejudice the petitioner or the defendant so much so that the result of trial is now unreliable? A federal court's deference to a state court's decision under 28 U.S.C. Section 2254D increases when reviewing an ineffective assistance claim. According to the Supreme Court in Harrington, we've got establishing that a state court's application of Strickland was unreasonable is all the more difficult. The standards created by Strickland and 2254D are both highly deferential, and when the two apply in tandem, review is doubly so. So, double the burden. 2 mountains to climb. The Strickland standard is a general one, so the range of reasonable applications is substantial. Federal habeas courts must guard against the danger of equating unreasonableness under Strickland with unreasonableness under Section 2254D. When Section 2254D applies, the question is not whether counsel's actions were reasonable. The question is whether there's any reasonable argument that counsel satisfied Strickland's deferential standard. What is more, the Constitution does not guarantee the right to an attorney in state post-conviction proceedings. Consequently, a petitioner cannot claim constitutionally ineffective assistance of counsel in such proceedings. Attorney error cannot constitute cause for a procedural default because the attorney is the petitioner's agent when acting or failing to act in furtherance of the litigation, and the petitioner must bear the risk of attorney error. So once you get into post-conviction proceedings, it is, you're on your own. This type of relief, even under the super high Strickland standard and the standards under 2254D, you're on your own once we're in post-conviction territory. So let's see. When the state has no constitutional obligation to ensure that a prisoner has competent counsel, the petitioner bears the risk of attorney error. In Martinez v. Ryan, the Supreme Court recognized a narrow exception to the Coleman rule, where under state law, claims of ineffective assistance of trial counsel must be raised in an initial review collateral proceeding. So in such cases, a procedural default will not bar a federal habeas court from hearing a substantial claim of ineffective assistance of counsel at trial if, in the initial review collateral proceeding, there was no counsel or counsel in that proceeding was ineffective. The Supreme Court also emphasized that the rule of Coleman governs in all but the limited circumstances recognized here. It does not extend to attorney errors in any proceeding beyond the first occasion the state allows a prisoner to raise a claim of ineffective assistance at trial, even though that initial review collateral proceeding may be deficient for other reasons. To excuse a procedural default under Martinez, a petitioner must show. So what are the standards here? We've got 1, the claim of ineffective assistance of trial counsel was a substantial claim, and 2, the cause consisted of there being no counsel or only ineffective counsel during the state collateral review proceeding. And 3, the state collateral review proceeding was the initial review proceeding in respect to the ineffective assistance of trial counsel claim. And 4, state law requires that an ineffective assistance of trial counsel claim be raised in an initial review collateral proceeding. So let's see. They're not going to seem to like this carrying forward, are they? They cite Martinez, where the Supreme Court considered an Arizona law that did not permit an inmate to assert ineffective assistance claims on direct appeal. In the Supreme Court's later decision in Trevino, the court extended its holding in Martinez to states in which a state procedural framework, by reason of its design and operation, makes it highly unlikely in a typical case that a defendant will have a meaningful opportunity to raise a claim of ineffective assistance of trial counsel on direct appeal. So Trevino modified the 4th Martinez requirement for overcoming a procedural default. Both Martinez and Trevino apply to Tennessee prisoners. So now they're going to analyze petitioner's claims. So under this petition, trial counsel performed deficiently by failing to A, have a mental evaluation performed on petitioner, B, call Ms. Wheeler as a witness, C, strike a work colleague of the victim's son from the jury, and D, conduct an adequate investigation, more specifically, for not testing the bloody fingerprints at the crime scene. And then another enumeration that trial counsel performed deficiently by failing to object to the trial court's incorrect jury instructions, and that the trial court violated petitioner's due process rights by denying his motion to suppress his statements to police. So the TCAA issue addressed issue 3 on direct appeal and the post-conviction appeal. Because he raised issues 3 and 1AD in state court, he has exhausted these claims. But he never presented issue 2, so failing to object to the trial court's incorrect jury instructions. So now we're narrowing what issues we're going to address here. So we'll address issue 2. He has not exhausted that claim. So for the sake of time, since they're going to say this was raised and exhausted, we'll skip those. They say that they analyze these under the Strickland rule. Let's see. When they're citing the opinion, I keep pulling in quotes from the opinion. And let's see. They're going to say that, hey, they reviewed the post-conviction court's opinion, and it considered these issues 1A through D under Strickland, the proper standard. And after reviewing the post-conviction testimony in the post-conviction court's decision, the TCCA, the Tennessee Court of Criminal Appeals, opined that the record fully supports the findings and conclusions of the post-conviction court. Trial counsel, a very experienced criminal defense attorney, offered a reasonable explanation for why he did not pursue a mental. So we read this decision, but they're citing it here, and they're going to say they applied the correct standard. This issue was exhausted. Another issue they're going to say was exhausted. Petitioner fails to show that counsel performed deficiently. So, in effect, issues 1A through D are petitioner's complaints about trial counsel's strategic decisions before and during trial. Petitioner argues that counsel should have performed a mental evaluation and that he should have called Ms. Wheeler as a witness. But when petitioner's co-defendant decided to testify in petitioner's defense, trial counsel's defensive strategy changed. Counsel decided to not bring some defenses or call certain witnesses. Trial counsel explained that petitioner's mental condition and ability were not seen as important in light of the new development with Ms. Vance agreeing to testify. Counsel also decided not to call Ms. Wheeler as a witness. So this is them, in their own words, agreeing with the Tennessee Court of Criminal Appeals decision. The counsel, it wasn't ineffective, it was a strategy call. Let's see. So she testifies that she remembers Snow and Tammy Hess coming and pulling up in the truck with the TV in the back of it. And what's more, Wheeler's testimony did not identify when she saw the television in the truck. All in all, this testimony did not help petitioner's defense. Trial counsel also made a considered decision not to strike the juror employed by the sheriff's department. He did so because there was no sufficient basis to excuse this juror because of some other factors favorable to the defense. And finally, trial counsel made a sound tactical decision against testing the bloody crime scene fingerprints, the reason that no physical evidence placed petitioner at the scene of the crime. And then in the end, petitioner's claims lack facts or arguments showing a reasonable probability that but for counsel's unprofessional errors, the result of the proceeding would have been different. So under the Strickland standard, they're saying his claim fails. Nor has he shown that counsel's decisions were objectively unreasonable. Plus, the district court presumes that a state court's factual findings are correct, absent clear and convincing evidence to the contrary. And petitioner here fails to assert an argument or provide any evidence that overcomes this presumption. So based on this court's review of the post-conviction testimony, as well as the trial transcript, petitioner has not shown that the strategic decision made by experienced, capable counsel were deficient. And so the court finds it appropriate to defer to the state court's decision on petitioner's ineffective assistance claims. So the court thus defines issues 1A through 1D. And we've got, holy moly, yay, we've got more green in the chat thanks to Sheriff Chuck. Thank you, Sheriff Chuck. Turning everybody green here. We'll say that these are our bingo cards being checked off. You know, Sheriff Chuck heard that we had a mention of gang tattoos, said our bingo card is checked. Let's get the 5 ticked off. Big thank you, Sheriff Chuck. We also have Aaron saying that generally appellate counsel is only appointed for direct appeals like an initial motion for new trial and state habeas petition. And yeah, when we finish off like sentencing proceedings, when we get to watch those, sometimes you'll hear the discussion with counsel in court, like, all right, you know, this judgment's going to be entered or whatever. And you might hear a mention, you know, that somebody else is going to withdraw and then tap in as counsel for the purpose of a direct appeal. So, and then Adventure Aaron says that's why so many people file PCR petitions pro se, despite only getting one bite at the apple in most jurisdictions. And what was that case recently? Let me scroll and see if I see the names over in our Discord. Was it Charlie Vaughn? Let me open the Charlie Vaughn chat. Okay, is there an easy way to open this? Speaking of this one bite at the apple that Aaron's talking about here in the chat, we talked about the case of Charlie Vaughn recently, and it is him that I'm thinking of. He submitted this letter maintaining his innocence, you know, and they considered this his one bite at the apple. So he did this pro se petition. This, what we're seeing on screen, was the petition, was what they considered the petition. They said that was his bite at the apple. So, hopping back over here, and again, thank you, Sheriff Chuck, sponsor of this stream and this cool Gamma document. So we've got issue 2. Petitioner claims that trial counsel provided ineffective assistance by not objecting to the trial court's incorrect jury instructions. So this is new, like we haven't really heard context about this issue, so we're going to read this one in full. Respondent, however, argues that the procedural default doctrine bars review of this claim. So the warden we're just going to say the state, the warden, is like, nope, procedural default, can't do it. So here, part of the argument they made was that the trial judge told the jury that to convict petitioner, it must find, quote, that the defendant, or one for whom the defendant is criminally responsible, unlawfully killed the alleged victim, and that the killing was committed in the perpetration of, or the attempt to perpetrate the alleged robbery. And that's cited back, and let's see. But the trial judge never defined criminal responsibility for the conduct of another. So back to this opinion, petitioner did not raise this issue in either his pro se or amended post-conviction petitions, nor did he raise the issue during the post-conviction appeal. His claim is therefore procedurally defaulted, unless he can show that the court should excuse his procedural default under Martinez. To do so, petitioner must show, among other things, that his claim of ineffective assistance of trial counsel was a substantial claim. And here, respondent argues that the court cannot excuse petitioner's default under Martinez because the claim is not substantial. So when reviewing this claim on direct appeal, the Tennessee Court of Criminal Appeals considered petitioner's argument and found, conceding that he failed to lodge a contemporaneous objection to the jury instructions, they're going to say you didn't raise it, so you waived it, provided by the trial court, and that he failed to include any issue related to the jury instructions in his motion for new trial. The defendant asked this court to review the jury charge for plain error in the trial court's instructions regarding the definition of criminal responsibility for the conduct of another. The state contends that the defendant waived plenary review of the issue and that the defendant has failed to establish plain error in the instructions provided by the court. Initially, as the defendant concedes, he has waived plenary consideration of any issue related to the jury instructions by failing to object to the omission at trial. And let's see. So they cite here that by failing to include it in his motion for a new trial, and then they cite to the Tennessee Rules of Appellate Procedure, in all cases tried by a jury, no issue presented for review shall be predicated upon error in jury instructions granted or refused, or other ground upon which a new trial is sought, unless the same was specifically stated in a motion for a new trial. Otherwise, such issues will be treated as waived. So exactly what Adventure Aaron is summarizing in the chat. Oh, interesting. So quick context on the Charlie Vaughn letter that we popped up on the screen. Also here, Charlie didn't even write that. Another facility resident helped him at the time this was sent to court. And Charlie did not know how to read or write. He had the cognitive capacity of an 8-year-old. And that's your one bite at the apple. And that's it. That sucks. And hey, Kristen. Hey, Kristen, good to see you. Kristen showing love to Aaron as well. We've got, let's see. So, otherwise, such issues shall be treated as waived. And then State v. Martin is holding that a defendant relinquishes the right to argue on appeal any issues that should have been presented in a motion for a new trial but were not raised in the motion. And then whether properly assigned or not, however, an appellate court may consider an error that has affected the substantial rights of a party at any time, even though the error was not raised in the motion for a new trial, where consideration of the error is necessary to do substantial justice. Substantial justice? Are there really like measurements for justice? Like, justice should just be. It either is or it isn't. But okay. All right, we're qualifying here substantial justice. That's what it's qualified under in the Tennessee Rules of Appellate Procedure 36B, and I'm sure elsewhere. Before an error may be so recognized, however, it must be plain, and it must affect a substantial right of the accused. Let's see. Steve v. Atkinson. Authority to correct an otherwise forfeited error lies strictly within the sound discretion of the appellate court, and the court should not exercise that discretion unless the error seriously affects the fairness, integrity, or public reputation of judicial proceedings. And that's United States v. Olano. In State v. Smith, this is just, it's like agitating to read like the case law here. Like, it's not a big deal. Let's ignore it. In State v. Smith, a Tennessee case, our Supreme Court adopted the definition of substantial right promulgated by this court in Atkinson. Atkinson. There, we held that a substantial right is a right of fundamental proportions in the indictment process, a right to the proof of every element of the offense, and is constitutional in nature. Our Supreme Court also adopted Atkinson's 5-factor test for determining whether an error should be recognized as plain. So A, the record must clearly establish what occurred in the trial court. B, a clear and unequivocal rule of law must have been breached. C, a substantial right of the accused must have been adversely affected. D, the accused did not waive the issue for tactical reasons. And E, consideration of the error is necessary to do substantial justice. So all 5 factors must be established by the record before this court will recognize the existence of plain error. And complete consideration of all the factors is not necessary when it is clear from the record that at least one of the factors cannot be established. So as soon as we get a nope, we don't have to keep considering the other issues. One nope is enough to exit the review. To be reviewable as plain, the error must have been of such great magnitude that it probably changed the outcome of the trial. And then finally, the burden of establishing entitlement to relief for plain error is on the defendant claiming it. And then they've got some case law here. Let's see, trial court's instructions. So let's see, an accused constitutional right to trial by jury encompasses a right to a correct and complete charge of the law. The trial court has a duty to give a complete charge of the law applicable to the facts of a case. The legal accuracy of the trial court's instructions is a question of law subject to de novo review. The propriety of a given instruction is a mixed question of law and fact to be reviewed de novo with a presumption of correctness. In its instruction on the offense of first-degree murder in the perpetration of a felony, the trial court told the jury that to convict the defendant, to convict Andrew, it must find that the defendant, or one for whom the defendant is criminally responsible, unlawfully killed the alleged victim, and that the killing was committed in the perpetration of or the attempt to perpetrate the alleged robbery. The trial court did not define the concept of criminal responsibility for the conduct of another. Indeed, the trial court did not mention the concept again. During its deliberations, the jury sent the following question. We have a jury question. And they ask about the exact thing. What is the meaning of criminally responsible as it applies to first-degree murder associated with aggravated robbery? The trial court responded, the definition of criminal responsibility is in the jury charge, and you're going to have to find that definition. It's already there. Talks about what that means, and in fact, is there several times all throughout the charge. Chat, what? What are we doing? What are we doing? Despite the trial court's remarks, the printed instructions provided to the jury do not contain any definition or further reference to the concept of criminal responsibility. That being said, the record clearly establishes that the omission of the instruction, even if it was erroneous, was harmless beyond a reasonable doubt. But the jury asked about it. Okay, I say this is an unreasonable conclusion, but I guess my standard of what's unreasonable, apparently that's not objective. The defendant was not charged under a theory of criminal responsibility for the conduct of another, and the only testimony that the victim was murdered. So this is the out. At least one of the outs. So the defendant was not charged under a theory of criminal responsibility for the conduct of another, and the only testimony that the victim was murdered by anyone other than the defendant came from Miss Vance, so Tammy, whose testimony the jury rejected out of hand. The defendant invites us to speculate that the jury's question evinced its consideration that someone other than the defendant committed the murder, but we cannot and will not do so, because any error in the omission of a criminal responsibility instruction was harmless beyond a reasonable doubt. The error did not adversely affect any substantial right of the defendant, and consideration of the issue is not necessary to do substantial justice. So, yeah. So the Tennessee Court of Criminal Appeals analysis on direct appeal explains that the trial court's error was harmless beyond a reasonable doubt, and the error did not adversely affect any substantial right of the defendant. Indeed, trial counsel did not perform deficiently by failing to object to the trial court's harmless mistake. This is because the state did not charge petitioner under a theory of criminal responsibility for the conduct of another. And this is so convoluted to me, because sure, the actual charge, the statute, is the murder statute. But if you're framing that the jury can convict, saying that he violated Tennessee laws, that specific statute, via, criminal responsibility, this to me is just convoluted. All in all, petitioner, especially you have the jury asking a question about the meaning of it in relation to the charge. All in all, petitioner fails to present a substantial claim of ineffective assistance and so fails to overcome his procedural default. And as a result, the court denies issue. So, issue 3. The petitioner alleges that the trial court violated his due process rights by denying his motion to suppress his statements to the police. But respondent argues that the Tennessee Court of Criminal Appeals applied the proper federal standard to this claim and that its decision was reasonable. So, they're going to agree with the warden here. After reviewing the trial testimony, the Court of Appeals, let's see that the state asserts that the trial court did not err by denying the motion and admitting the statements as evidence at the trial. At the hearing on the defendant's motion to suppress his pretrial statements as involuntarily given, Lieutenant Ragland testified, as he later did at trial, that as he interviewed the defendant, it became obvious that he knew more about the case than he was telling us. And as we continued to interview him, we felt it was prudent to treat him as a possible suspect. So then the defendant was advised of his rights, and he signed a waiver of rights form. Lieutenant Ragland testified that after the defendant had some difficulty reading the advice of rights form, he read the entire document aloud to the defendant. He said that the defendant never asked for an attorney, never refused to answer any questions, and never gave any indication that he did not understand the process. So, Lieutenant Ragland testified that the defendant was provided several breaks to use the restroom and smoke cigarettes, and that the defendant was offered food and water. He denied telling the defendant what to say, noting that the officers just wanted the truth. Upon further questioning, the defendant admitted that he'd gone to the victim's apartment to help Miss Vance retrieve a television to pawn, and that he had seen the victim's decaying corpse during that outing. Ragland presented that statement to Sergeant Mason, who then asked Sergeant Mullins to interrogate the defendant. So Lieutenant Ragland testified that after Sergeant Mullins interrogated the defendant, he asked Lieutenant Ragland to take a formal statement from the defendant. In that statement, the defendant admitted to killing the victim. Lieutenant Ragland adamantly denied berating or threatening the defendant to get him to provide an inculpatory statement. During cross-examination, Lieutenant Ragland acknowledged that he had basically accused the defendant of lying, telling him that his statements were inconsistent. Lieutenant Ragland said that the defendant did not tell him that he was a resource student. Sergeant Mullins testified that he interviewed the defendant in response to the defendant's interview with Lieutenant Ragland, and based on the information officers were getting from Ms. Vance, Sergeant Mullins said that when he confronted with all the information, the defendant admitted that he was there and that he killed the victim. Although he had knowledge of the crime scene from having visited it, Sergeant Mullins insisted that he did not relay any of that information to the defendant. So I think Mullins was blood spatter guy. He said that the details provided by the defendant during his confession matched the crime scene. Do you guys believe this? I don't believe it. According to Sergeant Mullins, after the defendant gave the detailed confession, Sergeant Mullins sent Lieutenant Ragland to get a transcriptionist to take the formal statement. Yeah, so he couldn't give this statement about what the scene looked like when he was speaking with Ragland the first time. Has to have this long, not feeding conversation with Mullins, and then after he has this conversation with Mullins, now let's go get a formal statement. That seems to math. As they began taking the formal statement, however, the defendant all of a sudden gets it all wrong. That's a quote. That's a quote. The defendant, quote, all of a sudden gets it all wrong. He's not describing it the same way he described it before. Yes, the unrecorded interview. Crazy. Crazy. He's not describing the same way he described it before. When Sergeant Mullins told him to start over again, this is so Brent Booth coded. The defendant started panicking, becoming upset, and claiming that others had committed the crime and threatened him and threatened his family if he told anybody. Sergeant Mullins said that the defendant started saying that Janice Jefferson, who he called Mom, had done it. He said a guy named Wayne Bobo had done it. He brought a couple of Hispanic names into it, everybody but Andrew Hayes. At that point, they stopped the statement. Sergeant Mullins said that even during his breakdown, the defendant never asked for an attorney, never asked for questioning to cease, and never indicated that he did not understand the waiver of rights. Sergeant Mullins testified that the defendant provided another statement after he spent several hours in the jail on a 48-hour hold. That statement, he said, was consistent with the one given before the defendant's breakdown on the previous evening. Oh, so they got him queued up to give a statement. He starts giving the statement. It's not what they want it to be. They hold him for 48 hours, and somehow the statement realigns with what they thought they would capture the first time they wanted to record it as a formal statement. Crazy. Sergeant Mullins maintained that he did not threaten the defendant or tell him what to say. Review all of his cases, please. During cross-examination, Sergeant Mullins testified that officers stopped questioning the defendant when it became clear that further interrogation would have been counterproductive for everybody. He acknowledged that they did allow Snow to confront the defendant after he implicated her in the victim's murder. He testified that he thought that Ms. Vance might have been the first to implicate the defendant, and he acknowledged that he confronted the defendant with Ms. Vance's statement. He denied telling the defendant everything that Ms. Vance had said, or that the defendant was interviewed in the room adjacent to Ms. Vance. Ms. Vance testified at the hearing that she heard detectives yelling and screaming at the defendant and using racial slurs. So, he's denying that, oh, we interviewed them, they were in rooms next to each other, meaning you could possibly overhear. And then the next line here says that Ms. Vance testified that she did in fact hear detectives yelling and screaming at the defendant using racial slurs. The defendant testified that he only admitted killing the victim because the officers told him he would not be released until he told them what they wanted to hear. He acknowledged that officers offered him food and drink, as they're legally required to, and that they told him facts about the crime and showed him pictures of the crime scene before he confessed. He also claimed that officers did not provide Miranda warnings until he had already provided a confession. During cross-examination, the defendant conceded that he traveled to the police station voluntarily in his own vehicle and that he had signed 2 advice of rights forms. So, obviously at trial, the state's like, but you signed 2 advice of rights forms, didn't you? You went to the police station on your own to talk to them, didn't you? The trial court denied the defendant's motion to suppress, concluding that the totality of the circumstances reflects an uncoerced choice to speak with law enforcement. The court accredited Lieutenant Ragland's testimony that he read the advice of rights form aloud to the defendant and observed that the defendant had signed 2 rights waivers and had initialed various parts of each incriminating statement. On appeal, the defendant again complains that the statements were the product of law enforcement coercion. We consider the claim with a few well-settled principles in mind. So trial court's factual findings on a motion to suppress are conclusive on appeal, unless the evidence preponderates against them. Thus, questions of credibility, the weight and the value of the evidence, and the resolution of conflicting evidence are matters entrusted to the trial judge, and this court must uphold a trial court's findings of fact unless the evidence in the record preponderates against them. The application of the law to the facts, however, is reviewed de novo on appeal. So the Fifth Amendment of the United States Constitution provides that no person shall be compelled in any criminal case to be a witness against himself. So, let's see. This is Mulroy v. Hogan holding the Fifth Amendment's exception from compulsory self-incrimination applicable to the statutes through the 14th Amendment. This means that to pass federal constitutional muster and be admissible at trial, a confession must be free and voluntary and not extracted by any sorts of threats or violence, nor obtained by any direct or implied promises. nor by the exertion of any improper influence or police overreaching. The rule is equally applicable to confessions given during custodial interrogations, following appropriate provision of Miranda warnings, and those provided before the defendant has been placed in custody. To determine voluntariness in reviewing, the reviewing court must examine the totality of the circumstances. And again, so what this court's doing is looking at the decision of the lower court and making sure that they ticked the boxes, but they're not reanalyzing the facts that would or would not lead the lower court to tick those boxes. They're just going to look and say, okay, we just saw the quote above from the court saying, we considered the totality of the circumstances. All right, we ticked that box. We found that this is post-Miranda. We found that there's testimony saying that the defendant understood, and we believe that he wasn't threatened or coerced. So this court's just saying, okay, that court ticked all the boxes they're supposed to tick. So they say whether the behavior of to determine voluntariness, the reviewing court must examine the totality of the circumstances surrounding the confession to determine whether the behavior of the state's law enforcement officials was such as to overbear the defendant's will to resist and bring about confessions not freely self-determined, a question to be answered with complete disregard of whether or not the defendant in fact spoke the truth. So Article 1, Section 9 of the Tennessee Constitution provides that in all criminal prosecutions, the accused shall not be compelled to give evidence against himself. The test of voluntariness for confession under Article 1, Section 9 is broader and more protective of individual rights than the test of voluntariness under the Fifth Amendment. And then we've got the critical question here from, let's see, State v. Smith, which cites State v. Stevenson and State v. Thacker, that the critical question is whether the behavior of the state's law enforcement officials was such as to overbear petitioner's will to resist and bring about confessions not freely self-determined. Upon our review, we conclude that the record simply does not support the defendant's claim of coercion. The defendant, in his late 20s, was provided with Miranda warnings. Ragland read both the warnings and the advice of rights form aloud to the defendant on at least one occasion. Although the defendant's interrogation on November 2nd was lengthy and no doubt intense, no evidence supports a claim that his will to resist was overborne. He was provided breaks to use the bathroom and smoke, provided with a drink, and offered food. Although this court has roundly condemned the 48-hour hold procedure utilized by the Memphis Police Department. Oh, that's interesting. That's they say, see State v. Courtney Bishop. Let's see. The record in the present case establishes that probable cause for the defendant's arrest existed at the time he was booked into the jail on the 48-hour hold. Under these circumstances, the trial court did not err by refusing to suppress the statements. So, then they're going to say, let's see. There's actually a note here that says this test is exactly the same as that promulgated in Rogers v. Richmond. So it is not entirely clear that it effectuates the stated goal of providing more protection to the criminally accused. So then we've got the Tennessee Court of Criminal Appeals correctly applied federal law on this issue. Under the Fifth Amendment to the United States, and we know, custodial interrogations, you have the right to not incriminate yourself. Miranda is cited here. A defendant may waive these rights provided the waiver is made voluntarily, knowingly, and intelligently. And they're going to argue here that Petitioner Hayes did so. He does not dispute that the officers gave him the appropriate Miranda warnings. Instead, he argues that after hours of questioning, officers created a statement allegedly given by Petitioner, and Petitioner was compelled to implicate himself. But the petition does not address the standards for evaluating habeas claims on the merits. As a result, it is unclear whether Petitioner contends that the Tennessee Court of Criminal Appeals decision was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, or whether it was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. Even if Petitioner makes these arguments, his claim still fails. And it says, because his claim fails under either standard, the court need not determine whether Petitioner brings his claim under either one. So it would not pass the test on either. And then we've got that the petitioner fails to show that the Tennessee Court of Criminal Appeals decision conflicted with clearly established federal law. So first, petitioner has not established that the Court of Appeals decision conflicted with any relevant Supreme Court decision. A state court's decision is contrary to federal law when it arrives at a conclusion opposite to that reached by the Supreme Court on a question of law, or decides a case differently than the Supreme Court has on a set of materially indistinguishable facts. So if you find, another case where the Supreme Court decided differently, and that case is like pretty much the same on the specific details, the different things that we're looking at, it's indistinguishable, then there could be an issue raised here. But they're going to say that the Court of Appeals used the correct rule from Miranda. And then at any rate, the contrary to standard under 2254 D1 does not require citation of Supreme Court cases, so long as neither the reasoning nor the result of the state court decision contradicts them. And they say that's the case here. The cases that the Court of Appeals cited do not contradict the Supreme Court's decision in Miranda. And then to be sure, the Court of Appeals also cited federal and state decisions. So we go beyond, Supreme Court decisions and we get to Tennessee cases. They also cited decisions that do not accurately reflect the current state of federal constitutional law as determined by the U.S. Supreme Court. So let's see. For example, Court of Appeals quoted Bram v. United States for the proposition that officers cannot obtain a confession by any direct or implied promises, however slight, nor by the exercise of any improper influence. But the Supreme Court has held that under current precedent, that passage from Bram does not state the standard for determining the voluntariness of a confession. So even though they cited Bram, the Tennessee Court of Appeals still applied the correct test, because they're ultimately going back to the Miranda standard. And let's see. Test for voluntariness is broader and more protective of individual rights than the test for voluntariness under the U.S. Fifth Amendment, U.S. Constitution Fifth Amendment. And then the Tennessee Court of Criminal Appeals here analyzed petitioner's confession under the Tennessee Constitution's more protective standard and found that his confession was voluntary. So Tennessee Court of Criminal Appeals not only got it right under federal standards, but they even looked at a stricter standard and found that Andrew's statement was all good. So this conclusion is thus not contrary to any Supreme Court decision. So here, this argument from the petitioner fails. And then we've got petitioner fails to show that the Court of Appeals decision unreasonably applies federal law. So they're going to end up saying the same thing, that to issue a writ of habeas corpus on these grounds, the district court must find that the state court's application of clearly established federal law was objectively unreasonable. And again, the habeas court they may not issue the writ simply because the court concludes in its independent judgment that the relevant state court decision applied clearly established federal law erroneously or incorrectly. So we can't just reanalyze the facts. And thus, as a condition for obtaining habeas corpus from a federal court, a state prisoner must show that the state court's ruling on the claim being presented in federal court was so lacking in justification that there was an error under well understood and comprehended in existing law beyond any possibility for fair-minded disagreement. So it's not enough that we might disagree and, whatever. That's not the standard that we can just decide as a federal court to say, we disagree with the lower court. They say petitioner does not show that the Tennessee Court of Criminal Appeals decision unreasonably applied Supreme Court precedent. And then applying the appropriate, quote, totality of the circumstances test, the Tennessee Court of Criminal Appeals held that petitioner's confession was voluntary. They noted that he was provided with Miranda warnings, and that even though petitioner's interrogation was lengthy and no doubt intense, there is no evidence supporting a claim that his will to resist was overborne. So, although petitioner disagrees, he's not established that it was so lacking in justification that there was an error well understood and comprehended in existing law beyond any possibility for fair-minded disagreement. So, you disagreed and that's not enough. So they say it fails. And then petitioner fails to show that the Tennessee Court of Criminal Appeals based its decision on an unreasonable factual determination. So we've got third, petitioner has not shown that the Tennessee Court of Criminal Appeals based its decision on an unreasonable factual determination. It's the prisoner's burden to bear to rebut the state court's factual findings by clear and convincing evidence. Plus, a state court factual determination is not unreasonable merely because the federal habeas court would have reached a different conclusion in the first instance. So, reasonable minds reviewing the record might disagree about the factual finding, but on habeas review, that does not suffice to supersede the trial court's determination. So here, petitioners raised no specific objections to the factual determinations that the Court of Appeals relied on, and the Court of Appeals found that the record supported the trial court's conclusion, and that the trial court did not err by refusing to suppress petitioner's statements. So all in all, petitioner has not shown by clear and convincing evidence that the state court made unreasonable factual findings. Deference to the state court's decision here is appropriate. And so, the court denies issue 3. In sum, petitioner's claims about issues 1 and 3 lack merit, and the procedural default doctrine bars issue 2. And as a result, the court dismisses the petition with prejudice. The court will enter judgment for respondent. And then, let's see. They say appellate issues. Petitioner has no absolute entitlement to appeal a district court's denial of a 2254 petition. The court has to issue or deny a certificate of appealability when it enters a final order adverse. So they're going to say, we're not even going to give you a COA. And then let's see, cases in the United States District Courts, petitioner may not take an appeal unless a circuit or district judge issues a court of appeals. A court may issue, not court of appeals, a certificate of appealability. A court may issue a certificate of appealability only if the petitioner has made a substantial showing of the denial of a constitutional right, and the certificate of appealability must reveal the specific issue or issues that satisfy the required showing. A petitioner makes a substantial showing when he shows that reasonable jurists could debate whether, or for that matter, agree that, the petition should have been resolved in a different manner, or that the issues presented were adequate to deserve encouragement to proceed further. And then the petitioner also does not have to show that the appeal will succeed. Even so, courts should not issue a certificate of appealability as a matter of course. So here, there can be no question that petitioner's claims lack merit. So because any appeal by petitioner on the issues raised in this petition does not deserve attention, the court denies a certificate of appealability. So this habeas petition dies here. And for the same reason the court denies a certificate of appealability, the court finds that any appeal would not be taken in good faith. The court therefore certifies under Federal Rules of Appellate Procedure 24A that any appeal here would not be taken in good faith, and the court denies leave to appeal in forma pauperis. So, and that's just citing that if petitioner files a notice of appeal, he must pay the full appellate filing fee or move to proceed in forma pauperis with the supporting affidavit in the Sixth Circuit Court of Appeals within 30 days of the entry of this order. So there we go. We are back. That's how we round out this pro se filing. Was there a date on this? I should have documented the date. So I see March 24th, 2022, but I'm pretty sure that's the filing. Maybe that's when it was published. So I'll have to go and update the date on this and see if that was the order date or when it was filed. Because I would imagine if it was filed in 2022. Maybe it says in the procedure background. Let's see. Yeah, I don't think it gives us a date. So I'll have to go and find out and perhaps see that updated. But what's cool is when I update it in my notes, it'll reflect the updates on the same link that's already in the description since it's a live site. All right, so then we move forward to 2024. We're going to see Jason Gichner. He's the new attorney now. He's who is arguing, the January 2026 Coram Nobis petition that we're going to read tomorrow. He also argued in front of the Court of Appeals towards the end of last year. But here's this timeline. We get to 2024, and here is the new initiatives that we're taking. So back at the trial court, the Coram Nobis court, we're going to use those terms interchangeably. In June of 2024, Hayes files his motion to reopen post-conviction proceedings and a petition for writ of error Coram Nobis. It was one motion that they file. And then the trial court in August is like, hey, can you separate these issues and treat them as separate cases? In October, the Coram Nobis court asked for equitable tolling to be addressed. So we heard about Clardy v. State when we were looking at the Zachary Adams Coram Nobis petition. Tolling, is there something new that makes this a timely raised issue? And in Zach Adams, the Coram Nobis court found that equitable tolling failed. And then here, they're going to make the same finding. On October 25th of 2024, Andrew Hayes filed amended petition for writ of error Coram Nobis and a brief addressing the impact for Clardy. In November, the court enters a final order dismissing the error Coram Nobis petition. So this first error Coram Nobis petition failed. And then 11 days later, Hayes and the state of Tennessee, and I thought this was interesting, file a joint motion for reconsideration with the trial and error Coram Nobis court. So there's a joint motion for reconsideration, right? For this Coram Nobis, this 2024 Coram Nobis petition. So I thought that was interesting. On the same date, Hayes also files a notice of appeal while this joint motion for reconsideration is pending. And the reason they do this is, hey, we don't think that there's going to be a decision here within the deadline we have to file this notice of appeal. So we want to file this on time and not miss out our chance to timely file a notice of appeal. So they file that notice, and then on February 27th of 2025, the appellant, so Hayes, files their brief. The state of Tennessee responds in May, the end of May, and then there's oral arguments, which is what we're going to watch here. It's worth noting that in November of 2025, the denial of the Coram Nobis, the appeal for the denial of the error Coram Nobis up here is affirmed. So this appeal, not this reconsideration prong, but this appeal ends up getting denied. So let's watch the oral arguments. And again, these oral arguments are, I have so many tabs open. This is going to be Jeff arguing.
Jason Gichner on behalf of Mr. Hayes.
No, let me slow it down. And this was August 5th. So we're going to be on August 5th, 2025. We are almost present day, because there's a lot less of video content to deep dive onto this. What we have in this is what I was able to find. Volume boost. Let's see.
Good morning, Your Honors.
Good morning.
Jason Gichner on behalf of Mr. Hayes. It is my first time appearing before two of you, and I'm grateful to be here with you today.
Mr. Gichner.
Gichner.
All
yes,
right.
ma'am. And I would ask to reserve 4 minutes for rebuttal, please.
Great, you may proceed.
Thank you. Andrew Hayes has spent almost 2 decades in prison for a murder committed by someone else. And this is a conviction that is grounded upon the confession of a man with a 62 IQ who was interrogated for about 27 hours without the benefit of counsel. Now, we are not here today asking this court to overturn his conviction and let him out of prison. We are asking for much more limited relief. We are asking for a day in court to present new evidence never heard by anyone, which proves that Andrew is innocent and that someone else is guilty. The primary issue I'd like to discuss this morning is the trial court's misapplication of the Clardy decision by denying equitable tolling. And as such, I intend to talk about 3 things. The evidence in this case is new. Taken as true, this evidence is clear and convincing proof of innocence. And while the Clardy decision provides instruction for how to properly plead an error Coram Nobis case to achieve equitable tolling, it was not intended to keep legitimate cases of innocence from the courthouse. The decision in this case was error and is an outlier from the other error Coram Nobis cases that have been decided by this court since Clardy. I'd like to begin and end by talking about Clardy and what it said. The Clardy decision emphasized that there's a distinction between the pleading requirement to achieve equitable tolling and the merits analysis for relief. To meet the pleading requirement in cases like this one, a petitioner must present newly discovered evidence that, if credited, clearly and convincingly proves innocence, and the evidence must be presented within a year of its discovery. Now, in this case, the trial court found that Mr. Hayes met the third requirement. The petition evidence was presented within a year of its discovery. What we need to talk about today is why the evidence in this case is new and satisfies the clear and convincing pleading standard. And it's important to keep in mind what the Supreme Court said about this kind of evidence at the tolling stage. The Coram Nobis court should assume arguendo the veracity of the new evidence cited in the Coram Nobis petition for the purpose of assessing whether to toll the statute of limitations. Now, a little bit of factual background about this case I think is helpful as we consider the new evidence. There were two competing theories that were presented at the trial in this case. The state argued that Tammy Vance and Andrew Hayes committed this murder, and the defense argued that Tammy Vance and Sarah Lucas committed the murder. There wasn't any physical evidence that tied Andrew Hayes to this case. As I said earlier, he was essentially convicted based on his confession. In fact, to quote the lead detective of the case at trial, "I don't know of anything that links him specifically to the crime other than his confession, but that's compelling enough for me." And when we talk about the confession, I've already mentioned that this is a man with pretty significant cognitive disabilities, but it's also important to keep in mind what he actually confessed to. After 27 hours, Andrew Hayes confessed to hitting the victim in the back of the head on the second story of the victim's apartment 2 weeks prior to his interrogation. None of that is true. The victim in this case was not hit in the back of the head. He lived in a one-story apartment, and the murder in this case happened months before Andrew Hayes was ever interrogated. So we have a man essentially convicted based upon a confession that is objectively untrue under circumstances that I would argue were coercive.
Didn't he mention that Tammy Vance threw a container of bleach at the victim?
I'm sorry?
In his confession, didn't the defendant say that Ms. Vance had thrown a container of bleach?
So there.
Now, this question instantly pisses me off because it's like, his mindset, he's thinking something in the confession matches the crime scene. And it's the idea that only someone with personal knowledge could confess to, that's the only way they would know this detail. But it's skipping over the entire issue of Sergeant Mullins. Before we get this attempt at transcribing a first official formal statement, Sergeant Mullins, blood spatter guy, noted, and there were crime scene photos, I think, as much, that show the lighter spots on some of the fabric in the carpet. So if Andrew Hayes was given that description or given that information and or shown pictures of these lighter spots, that could be how he would come up with a quote-unquote confession with details that seem like personal knowledge that only the actual perpetrator would have, had it not been for Sergeant Mullins feeding crime scene details to someone during a 27-hour interrogation. But that's where this guy's mindset is. Listen to his question again. And it catches him off guard. Like, he's got to be like, really, dude?
That I would argue were coercive.
Didn't he mention that Tammy Vance threw a container of bleach at the victim?
I'm sorry?
In his confession, didn't the defendant say that Ms. Vance had thrown a container of bleach?
So there are parts of his confession that the officer testified that Andrew Hayes said. I would point out that this interrogation was neither video nor audio recorded, despite the fact that he was in custody for 27 hours. So there are aspects that the police said he said that are consistent with things at the crime scene. There are other things that the police say he said that are objectively untrue with evidence from the crime scene. So yes, it's fair to say that according to the police, he said things that were consistent with evidence at the crime scene. That's fair.
Okay, for purposes of this appeal, that you're arguing, basically, you're making a sufficiency of the evidence argument. That's been rejected. You know that.
I do. And I only point that out, Your Honor, because I think the context of that information is important, particularly when we talk about what the new evidence in this case and how that new evidence applies to that context. So let me talk about that.
Please.
First of all, we have 5 new witnesses that are willing to come to court that say that Sarah Lucas confessed to this crime.
Do any of those witnesses have firsthand knowledge that Mr. Hayes did not commit this offense?
So Tyler Landers does.
Firsthand knowledge.
Yeah, he overheard a conversation, which is in his affidavit, between Sarah Lucas and his mother, Heather Balderas, who was Sarah Lucas' sister.
How is that firsthand knowledge? That is
well, he has firsthand knowledge of the
hearsay.
confession. Well, he heard her say that she committed the crime.
Would he be able to testify to that in
Yes.
court? How?
So let me address the admissibility arguments.
Please.
So I would say that there are a variety of reasons why the evidence in this case is admissible. First of all, I would say that the alleged hearsay isn't being offered for the truth of the matter asserted. It's being offered to show that Sarah Lucas committed the crime, not that Andrew Hayes
If
is
it's not
innocent.
being offered for the truth of the matter asserted, then what is the point of putting it in Coram Nobis affidavit?
Well, certainly I believe the substance of it, that she committed the crime, but it's also being offered to show that all of these specific facts that these witnesses have to say are true. But let me even talk about the hearsay exceptions and beyond the hearsay exceptions, why it's admissible. So let's look at Rule 804, all right, which is the admissibility of evidence when it's hearsay coming through an unavailable witness. Heather Balderas is deceased, okay? So she can't come and testify. Heather Balderas was involved in this crime. She was called from the crime scene from her sister within 20 minutes. She was called from the victim's cell phone like 50 times in the 2 weeks following the murder. I don't think there's any question that she was involved with her mother and her sister taking money out of the victim's ATM account, talking to them about covering up the crime scene. No question that.
Okay, I'll even give you that. I'll go there with you.
Okay.
But how does that disprove the defendant's guilt and show that he's actually innocent?
The overwhelming evidence in this case was one of two things, which is either Tammy Vance and Sarah Lucas did this, or Tammy Vance and Andrew Hayes did this. This isn't a Clardy case, right, where you have multiple people. So the argument in Clardy was, well, he could have been one of those two.
Reversed
I
in
know.
Clardy.
I was at Austin P when that was argued in front of you, and still represent Thomas Clardy, so I'm very familiar with it. But it's not that case, right? I mean, the evidence in this case is that it was either Andrew Hayes and Tammy Vance, or it was Sarah Lucas and Tammy Vance. It's one or the other. So if there's no question that Tammy Vance did it, I don't think anybody doubts all of the overwhelming evidence from both sides that she was part of this.
So you're throwing names at me. Mother, daughter, which
Tammy Vance's mother, Sarah Lucas's daughter.
Okay, and then your other.
Andrew Hayes, my client.
Right, I know who your client is, but you threw some other names out there. If you could just communicate, because I get lost in the names.
Sure.
The mother basically pled guilty as well, claiming for the benefit of our analysis here that she was taking the charge for her daughter.
Correct.
And the daughter denies anything in all the affidavits that you submitted in this petition. She denies any involvement in this whatsoever, says mother is crazy as a loon.
Correct.
Okay. So I just want to be clear about what we're talking about.
But let's talk about why the daughter's position on that is not believable, particularly in light of the new evidence. So
you're asking this court to make credibility determinations about a witness in an affidavit?
I'm asking this court, per Clardy, to assume what these people say is true and that their credibility should be tested at a hearing.
Clardy doesn't require us to get to that point until you establish in your petition that the evidence is new evidence, which presupposes that it is admissible. You've not demonstrated that yet.
So let me talk about why the evidence is admissible. So these other people are going to come to court and they're going to say, Sarah Lucas has admitted she committed this crime, and they're going to discuss the circumstances of how she committed the crime. They are going to say that she hit the victim in the head with a hammer. They are going to say that she stole his truck.
You've lost me. So this again is going to the daughter being guilty of the offense.
Sarah Lucas.
Okay, so again, this is not going to actual innocence of the defendant.
If we prove that Sarah Lucas is the murderer, it follows that Andrew Hayes was not. because it is either one or the other.
How is it necessarily one or the other?
Under everything we know about the facts of this case, the state's, it's always been that two people committed this crime, but let me even speak to objective physical evidence why we know that it was Sarah Lucas and Tammy Vance at the victim's apartment the morning that he was murdered, all right, and not Andrew Hayes. We have cell tower records from that morning that were never presented to a jury. And what we can establish through those records is that on the morning of the murder, Sarah Lucas and Tammy Vance were in the victim's apartment when he was killed. 20 minutes later, from the victim's apartment, with his cell phone, the first call is made to Sarah Lucas's brother, a man named Miguel, boyfriend, a man named Miguel Famat. The second phone call is made to her sister, Heather Balderas. Later that afternoon, his ATM card is used to steal money from his account. Within days of this, Sarah Lucas is pawning his stolen property at pawn shops that she lies to the police about. And we can prove through the cell tower records that they were in that apartment. The other reason we know that they were together that morning is that we can prove through cell tower records that the victim is in West Memphis, Arkansas, about an hour and a half before he's killed, at the same exact location where Sarah Lucas is, getting her state driver's license identification. And she's there with him. And all of these other witnesses are going to come to court and say she has made admissions consistent with this information. Not only does the cell tower data show that Andrew Hayes isn't there that morning, Andrew Hayes doesn't even meet these people for like another month when they move into the apartment to live with a woman named Janice Jefferson, that he was also living in that house. So
how are Ms. Lucas's statements to these new witnesses, how are those admissible?
Well, I would argue that it's admissible because under 804, but I would also argue that under a Chambers analysis, these statements are admissible. So Chambers, which was incorporated in Tennessee by the Brown case, says that evidence is admissible despite potentially being hearsay if it's crucial to the defense, reliable, and the balance of interest for inclusion outweighs exclusion. And what I would say is that Chambers specifically states, excluding evidence of a third-party confession violates due process. So I believe that all of this is admissible on its face. I would say at a minimum, if there is a question about admissibility, that's a reason why you have a hearing and you hear what the evidence is and conduct a Chambers analysis when you can assess the credibility of the witnesses and hear what they have to say.
What's your take? How much does clarity allow the trial court to look at admissibility? We know, we set credibility aside, we assume arguendo that they are credible, but what about admissibility?
I think it's a little bit of an open question. I mean, the Logan decision speaks to that issue about admissibility, but Logan was decided pre-Clardy. I would argue that the admissibility question should be part of the merits analysis, but I also think you're going to be stuck with cases like this one.
But Clardy cited Wilson with approval, and Wilson specifically says it has to be admissible. I mean, that's the whole point of the statute. It presupposes that the evidence that's pled in the petition is admissible. And I'm sympathetic to your argument. But that is what our law says. Clardy cited Wilson, period, point blank, and they're interpreting the statute, explicitly the statute, that presupposes admissibility.
Right, but what I would say in response to that is that the admissibility question can't always be resolved just by looking at the pleadings, right? Because there are cases where you have to do a Chambers analysis where you have to actually see if you believe these people to see if it qualifies under Chambers. Now, I would argue that the evidence in this case is admissible on its face under Rule 804. I would also argue that it is admissible on its face under Chambers. So I believe we have met admissibility. I would also argue to this court that there is new evidence beyond just these new witnesses. There is new scientific evidence that is related to the coercive interrogation that's incredibly powerful and
What
relevant
is
in
the
the case
new
law.
evidence regarding coercive interrogation?
There's an expert that will testify to the psychology of the coercive nature of the investigation.
Was that not available at the time of trial?
So the science itself could have been available, but the developments since this trial in 2010 are extensive. And the report is in the petition, so you can see what's cited in the report.
Because, correct me if I'm wrong, it was contested. The admissibility of the confession was heavily contested pre-trial.
It was, and I'm not making an argument related to the suppression of the confession.
I understand.
Yeah, you're right. It was contested, and the court ruled that it was admissible. But I would argue what's important about this new scientific evidence is the developments in the science related to the coercive interrogation, particularly in a case like this where you have somebody that's convicted pretty much entirely based on his confession. So a couple other points I want to quickly make.
Sure, I know you're running. We're
I know
asking
you're asking important questions. Unfortunately, there are a lot of issues in this case. But I think it's also important to talk about the basis of the denial by the trial court in this case.
And the trial court here issued a 38-page opinion, okay? She was meticulous.
Look at the state nodding behind.
To talk about the basis of the denial by the trial court in this case.
And the trial court here issued a 38-page opinion, okay? She was meticulous in addressing the analysis in clarity, alternative analysis. So I need for you to really narrow down what you think the trial court did wrong here.
Sure. So the trial court didn't even address the admissibility issue. The trial court said, this doesn't mean equitable tolling because...
Oh, wait, let's run that back.
Alternative analysis. So I need addressing the analysis in clarity, alternative analysis. So I need for you to really narrow down what you think the trial court did wrong here.
Sure. So the trial court didn't even address the admissibility.
Meticulous in alternative analysis. Oh, the trial court didn't even address the admissibility issue.
The trial court said, this doesn't mean equitable tolling because it's cumulative for the purposes of impeachment, all right? The problem with the trial court's analysis is that it only went halfway in its analysis. What the court said is that newly discovered evidence, which is simply cumulative to other evidence in the record, will not justify relief. Now,
why isn't that enough?
Because it only goes halfway. And if we look at the Avant decision, what the rest of that sentence is, when the evidence might not have resulted in a different outcome. So what the case law is saying is that if you have evidence that is either cumulative or impeachment, but it is strong enough, particularly when it's evidence of somebody else confessing to a murder, that is good enough for error coram nobis relief. And let me also quote what Justice Koch said in Harris versus State. There's no question that an authentic confession by a third party to a murder is critical to a person's defense in the context of error coram nobis analysis. And let me also point out, as it relates to impeachment, what the Tennessee Supreme Court said in the Vasquez decision. Impeachment evidence might be particularly compelling under the circumstances of a particular case. Moreover, a complete restriction on the availability of coram nobis relief.
Did somebody just sigh into the microphone? By somebody, I mean, you guys know who. But somebody sighed, right?
Decision. Impeachment evidence might be particularly compelling under the circumstances of a particular case. Moreover, a complete restriction on the availability
right there. It's like
of coram nobis relief in the case of any newly discovered impeachment evidence would be inconsistent with the discretion afforded to trial courts. And of course, the language in Tennessee Code annotated 4026-105 makes no distinction between impeachment evidence and all other evidence. Thus, the ultimate question is the effect of the newly discovered evidence in the outcome. So what the trial court said in this case is, this evidence is cumulative for impeachment purposes, and that's not a basis for error coram nobis relief. That's not what Vasquez says. That's not what Avant says. That's not what Teague or Waldorf say. The evidence has to be good enough. Now, the other question is whether the evidence qualifies as clear and convincing evidence of innocence. And I think the best way to answer this question is look at the other decisions that have come down from this court post-Clardy on this question of who meets equitable tolling and gets a hearing and who doesn't, all right? The cases where we see courts granting equitable tolling have less new evidence of innocence than this one. In the Garner decision, where you have...
You need to wind it down.
Okay. Sorry, I know I'm over.
Yeah.
I can talk about this in rebuttal, but the only point I would make about this is that Garner, McKissick, Avant, these are all cases that have less evidence, new evidence of innocence than we have in this case that results in equitable tolling and a hearing, which is why there should be a hearing in this case.
Thank you, counsel.
Thank you.
Jenna?
The state. Okay, it's irritating me that the flags aren't, like, center framed here. Something's not aligning right here. Oh,
It's
God.
good to see you, General Coleman.
Good morning, Your Honors, for the next 6 minutes or so. And may it please the court, Ronald Coleman on behalf of the state. This court should affirm the denial of Coram Nobis relief because the Coram Nobis court properly found that this untimely petition did not warrant tolling. Before I get into sort of that, I do want to provide a little bit of a factual background. I think it's important to, not just for the victims that are watching, but also just to contextualize things. So on August 20th in 2007, the defendant beat the victim to death with an iron pipe. The proof at trial showed that police questioned the defendant, and he gave details that they said only the perpetrator could know before he ultimately confessed to the murder. He told a number of unique details that they found to be suspicious and indicative of his involvement, but ultimately told them that he hit the victim in the head with an iron pipe, that he did so multiple times. He talked about this co-defendant, the mother named Vance, how she shoved a rag into the victim's mouth. He also talked about how that she eventually tossed some bleach onto the victim after he was deceased.
And remember, he's playing right into the question from the first justice that's sitting on the left-hand side. But wasn't there evidence of bleach?
And provided other details as well. Police were able to corroborate this confession. They said that the crime scene evidence, the forensic evidence inside, corroborated the fact that this victim had been hit multiple times in the head with a large blunt object like an iron pipe. And then it's important to note, further contextualizing this statement, police started to take a formal statement after the defendant had confessed to his involvement, and the defendant changed stories a little bit, but it's important to note that he always said that he was still present. He tried to blame, I think, 4 separate individuals as being the one who landed the lethal blow, but never said, well, I was never actually there. Always said he continued to be there. And then the following day when police came back and interrogated him again, he once again admitted to murdering the victim by hitting him with...
That's simply not true. He's saying, he's representing in this court that he never once said he wasn't there.
Note that he always said that he was still present. He tried to blame, I think, 4 separate individuals as being the one who landed the lethal blow, but never said, well, I was never actually there. Always said he continued to be there. And then the following day when police came back and interrogated him again, he once again admitted to murdering the victim by hitting him with a metal pipe in the head multiple times. Again, this was corroborated. And what was also corroborated is that at some point shortly thereafter, he was seen carrying the victim's large television back to his house. Despite all of this proof, the defendant still was able to present a vigorous defense at trial. He had a doctor testify that he had a somewhat low IQ. His former girlfriend attempted to lay the blame with the co-defendant, Vance, and with Vance's daughter named Lucas, tried to say it was them. The defendant testified on his own behalf. He, in fact, presented just how vigorously the police interrogated him and sort of complained that he never meant to confess, he just didn't really know. So he told the jury this information, and then the co-defendant, Vance, testified on his behalf and explicitly told the jury, I was throwing him under the bus to save my daughter Lucas. Lucas is the one who did it. The jury discredited these witnesses and found the defendant guilty of first-degree murder. Now the defendant seeks Coram Nobis relief on a number of different pieces of information. But the first and penultimate question that we're here for is whether he's even entitled to tolling the statute of limitations. And Clardy, our Supreme Court, clarified what a defendant has to do to establish tolling. And I think it's important that the 2 points that the defendant cannot make here. First, he cannot establish that the information presented was newly discovered evidence. And second, he cannot establish that this was proof of actual innocence. So first, I believe, Judge Hickson, you asked, how much do we look at admissibility when we're looking at the tolling analysis? And it's important that Clardy used a term of art, newly discovered evidence, which has been defined by the courts. It's not just that it's new. To be newly discovered evidence, it has 3 requirements. It has to exist but not yet be ascertained at the time of trial. It has to be admissible, and it has to be credible. Now, Clardy said we sort of presume that third prong. That we just kind of, when we're looking at this threshold issue of tolling, we presume that it's credible, but it still has to meet the definition of newly discovered evidence. So it either has to have existed at the time of trial, or it has to, be admissible. None of this new information that the defendant submitted with his Coram Nobis is either of those, or is both of those. To Judge McMullen, your point, with these new witnesses and these affidavits, none of this is admissible. This is hearsay, sometimes hearsay within hearsay, and the defendant did not present any argument below, at least my understanding of the record. I am filling in for Davy Douglas, so the record is more accurate, but my recollection is he didn't even argue that this met the burden of admissibility under any rule or statute or
What
case.
about his argument here today that Ms. Lucas's third-party confession would be admissible under Chambers and Brown?
I think because it's still hearsay, it would be precluded. And even if it weren't, even if it sort of constituted newly discovered evidence, it still doesn't meet the second prong of actual innocence. Again, the defendant, even when he attempted to sort of recant his confession, always stated that he was present. And the defendant sort of seems to make this logical leap that if Lucas was involved.
So even after he tried to recant, now we're getting a timeline. Since this point in time, he never said again that he was the only person there. So now we at least have an acknowledgement that what he represented earlier was only half of the context.
If the daughter was involved, then inherently he just simply could not have been. That's not what the proof shows. And that's not, there's nothing here that negates the defendant's involvement or shows a clear lack of involvement. This isn't an alibi where someone said, oh, I was actually with him at the time, because we know exactly when the murder was. The victim here had a pacemaker, and so we can tell the exact moment that he passed away, or that he was murdered. We don't have evidence of actual innocence saying the defendant was actually with me on that day at this time. Instead, what we have is cumulative impeachment evidence of, even if it came in, it just would bolster his defense, which he vigorously presented at trial. I think one thing that he says too, that I want to point out is that the court only went halfway with regard to this cumulative impeachment evidence. He misconstrues the standards because we're doing 2 different tests. I don't think Vasquez or any of the other cases that he cites deals with whether tolling is appropriate. And if we're looking at the merits after tolling or if under a timely petition, then maybe, because I think what the Supreme Court is saying is you're not precluded from ever having impeachment evidence or cumulative evidence that could or might change the outcome. But here, we have a higher bar under Clardy, and that bar is clear and convincing evidence of actual innocence. It's not that this might have changed the outcome at trial. It is that this is clear and convincing evidence that he did not do the offense that he's convicted of. And the defendant simply can't meet that burden. So the state's position is, first and foremost, none of this information is newly discovered. These witnesses, it's all hearsay, none of it's admissible. The defendant hasn't established that it's admissible. And some of the other things I want to talk about is this new scientific evidence that he mentioned today. To your point, Judge McMullen, this was already known at the time of trial. In fact, trial counsel commented at post-conviction that he thought about getting an expert to help with his suppression issue. And my friend on the other side seems to have countered that, well, these are developments that have happened since the trial was completed. But that goes back to newly discovered evidence, which has to be existing but not yet ascertained at the time of the trial. So if the reason that this is newly discovered is because it happened after the trial, then it is inherently not newly discovered evidence. And then last, I think the only other thing that he talked about today was these cell phone tower records. That's not newly discovered evidence. That's not even evidence considered in the Coram Nobis petition. He's not attached that. He asked this court.
But he did. So Jeffrey Gichner represented that as something that the jury has never heard about.
Sort of consider it in context with other proof at trial and post-conviction because it was in the state's file. But he relies on a case that seems to find that you were allowed to consider Brady evidence that was improperly withheld from a defendant. This was in the state's file. There's been no finding that it was improperly withheld. It just wasn't presented to the jury. So these cell tower records cannot be considered at all, but certainly they're not part of the Coram Nobis petition. I think those are the only points that were discussed today. Unless this court has further questions, I'm happy to rely on the remainder of my brief. But again, none of this information is newly discovered evidence. None of this information is evidence of actual innocence. For that reason, the post-conviction or the Coram Nobis court properly found that the untimely petition did not warrant tolling. We ask that you affirm.
Thank you, counsel.
Thank you.
Mr. Gichner?
Thank you. Let me respond on just a few of those points. So first of all, Chambers and Brown are hearsay cases. That's what those cases are about. You know, if you have a third-party confession, if it's hearsay, due process tells us we should still hear that third-party confession, which is why the evidence is admissible in this case, because all of these people will come to court and say someone else confessed to the murder. The second point I would make is that...
I'm sorry.
Go ahead.
Who is going to say that Miss Lucas confessed that she did it? And how does that clearly and convincingly demonstrate that the defendant, Mr. Hayes, did not?
So all of the people who will come in are Miss Lucas's family members. These are people who don't know Andrew Hayes. They've never met Andrew Hayes. They don't know anything about him. They know because either they heard her say it or they heard it from their mother who's deceased that she confessed to it. So these are all her family that will come in and say it. And then let me address your second point, which I think is important. And this is why the other evidence, the cell tower data, is important because it provides context to this new evidence. And first of all, these were exhibits to the petition that were filed. So this is all part of the record that's before the court. What that cell tower data proves is that on the morning of the murder, and counsel's right, we know exactly when this person was killed because he had a pacemaker. We know where he was because we can track him through his cell tower records and cell phone, and we know who was with him. So we can see through those records that when he was killed, he was with Tammy Vance and he was with Sarah Lucas, and he was not with Andrew Hayes. That's why all of that information matters, because it provides context to these family members who are going to come in and say she confessed to it.
Is that because the record shows that Mr. Hayes is elsewhere at that time?
Well, we can see that he's not. We can follow the cell phone that morning, and we can see the stops that are made, and we can compare and contrast that to the trial testimony of Tammy Vance and Sarah Lucas and see where they were. So what we can see from these records is they start out that morning in Cordova, which is exactly what Miss Vance says. They drive over to her daughter Sarah Lucas's house and pick her up. We can see it in the cell tower records. They go to West Memphis, Arkansas. We can see it in the cell tower records, and it's confirmed by the identification that Sarah Lucas got at the DMV that morning. And then we see them drive back to the apartment, not stopping at Sarah Lucas's place. And within a very short period of time of that, the victim is killed. And then within 20 minutes of that, his cell phone starts calling Sarah Lucas's boyfriend and Sarah Lucas's sister. And nowhere on that map do we see any stops or any connection to Andrew Hayes. We also know that Andrew Hayes doesn't meet these people for weeks until after this event. So we can track that evidence. So how does it get in? And this gets to the Johnson case the counsel was just asking about, saying this isn't admissible. I would argue that this court should consider the entire record of the case. And that's what Johnson says. It's not just about evidence that is withheld as a Brady violation. It's the spirit of, let's get to the truth of this thing, right? I mean, that's what the McKissick case says too. We should look at the entire record. And if we have objective physical evidence that shows two people with the man when he's murdered, and we use that as context for 5 witnesses who are family members of these people who are going to say that one of them confessed to this murder.
But I understand your time's about to run, but those 5 family members are going to say exactly what the mother testified to at the defendant's trial. And that is, she was covering for the daughter because the daughter is the one who actually did this. That was testimony at trial that the jury rejected. And that, to me, is part of what the Coram Nobis court was trying to say. This is all basically cumulative of what mother testified to at trial.
So they have information beyond what mother said about the financial arrangement, about the circumstances of how the murder happened. But what I would argue, Your Honor, is that if the evidence presented at trial was true and rejected by the jury, and it proves that he was innocent, and we have lots of people after the fact that are going to come in and say, you got it wrong because this person has confessed to committing the crime, and we know the details and circumstances of how she did it, and we can back that up with objective physical evidence that proves it's true, and she did it, and this other guy didn't, that should meet equitable tolling for the purposes of having a hearing. We are not asking you to turn him loose or overturn this conviction. All we're saying is that there is a mountain of evidence in this case that the wrong person is in prison and he can't even get a day in court. That shouldn't be where we are. It is also inconsistent with all of these other cases post-Clardy, where people have less new evidence of innocence that has resulted in equitable tolling and has resulted in hearings, which is why this case is an outlier, and we would ask this court to find equitable tolling and remand it for a hearing.
Thank you, counsel.
Thank you.
Well argued, well briefed. The matter will be taken under advisement. I think that concludes our morning docket. We'll be in recess until lunch
So this initiative is denied. I want to play another small clip from the Everything They Missed podcast. Again, please, like if you're looking for something to do tonight, because tomorrow we're going to get back together. We're going to read the new 2026 era Coram Nobis petition. I want to play Stephanie Tinsley's reaction to this hearing. So let me cue that up. But again, in 3 hours or less, so if you speed it up, you can get through it faster. In about 3 hours, you can get through all 6 episodes of the podcast. It's a bit longer than 3 hours, but close enough. Let me cue this up. I think it was about 25 minutes into this portion. Let me see. Because I remember she says she calls her husband Mark Tinsley, who might be a familiar name from the Alex Murdaugh trial. Get some captions. And she calls Mark because she's troubled by walking out of this hearing and the vibe of the judges. And now that we've gotten to watch that, I feel exactly what Stephanie says she feels from listening to this panel respond to what they're hearing.
Hearing them done?
Yes. Well, they just asked why he thought that this was new evidence. I mean, that's what they really were hammering home. On the drive home, I called my husband Mark just to download it all, to talk through what had happened, how it really felt. I mean, he was well prepared. He argued very well. He had his case law. They let him argue well over his 20 minutes. So he's got 20 minutes, 16 minutes to argue, and then 4 minutes for a rebuttal. He argued well over that both times. But, you know, they were pretty much they asked a lot of questions. The lady judge was the one that asked the most questions, and you know, she was just basically saying none of this seems new.
What was the state's position? What did the state say?
That Judge Skane was right, and I'm trying to think. I don't know.
Yeah,
it's all kind of running together, but it's on Elizabeth is watching it right now. It's already on YouTube, but you know, I think one of the things the state was saying was it doesn't prove that Andrew wasn't there. You know, it doesn't matter if
technically, if he didn't know Annie Harris, it does prove he wasn't there. But I don't disagree but that's not new. But
So
you know,
Jason was trying to argue that the totality of all of it shows that he's not, because he kept trying to argue the case, and one of the judges stopped him and said, "We're not arguing the case." But I don't know. I mean, I think you'll watch it and you'll say the same thing that you said when you read the petition. Judge Skane wrote a very thoughtful belt and suspenders response, and there's nothing new.
unfortunately,
So yeah, and as Jersey Girl Trey says in the chat, her reaction was so deflating. And I think the perfect way to end, where we're going to pump the brakes today, because tomorrow we're going to get together and we're going to look at what happened this January with the new Coram Nobis petition. If this appeal makes you feel deflated, don't feel that way. Let me read you a page of what we're going to look at tomorrow. So in the past few months, and this is super tiny, in the past few months, new evidence has come to light that definitively proves Andrew Hayes' innocence. The new evidence is Sarah Lucas, in her own words, describing the morning of Danny Harris's death. Her statements prove that all her prior testimony was untruthful and that Mr. Hayes had absolutely no involvement in the murder of Danny Harris. Sarah Lucas admitted that only she and her mother were in Danny Harris's apartment on the morning of August 20th, 2007, that she saw her mother hit Danny Harris repeatedly with a hammer, that she helped her mother by holding him down during the attack with the pillow, that she vomited on the bathroom floor, that she and her mother attempted to clean up the crime scene, that she knows Andrew Hayes is innocent, and that she has no intention of sharing what she knows because she fears legal consequences. The new evidence comes in the form of recordings of conversations between Sarah Lucas and one of Danny Harris's sons, Stephen Harris. Stephen Harris, after hearing the oral argument in Mr. Hayes' appeal on August 5th, 2025, what we just watched, decided to independently investigate his father's murder by building a friendship with Sarah Lucas. He gained her trust over a period of weeks, spending hours on the phone with her, and she eventually revealed critical information of Andrew Hayes' innocence. Stephen Harris recorded all of their conversations and has provided defense counsel with 3 recorded phone conversations. In the first recorded call, Sarah Lucas maintained her charade of non-involvement, but made statements that contradicted her trial testimony. In the second recorded call, Sarah Lucas finally admitted the truth, that she and her mother murdered Danny Harris and that Andrew Hayes was not involved. In the third recorded call, Sarah Lucas explained that she will not come forward with the truth, even though an innocent man is in prison, because she fears facing her own legal consequences. So, don't feel deflated by that hearing. At least, not in the sense that that's where it ends, because that hearing led to a family member of Danny Harris deciding, maybe something doesn't seem right here. I don't know exactly the feeling, what the impetus was, but he goes and he befriends Sarah Lucas, and he gets these confessions that are now the turning point for DA Steve Mulroy to say, look, we've got to right this wrong. We are now arresting Sarah Lucas right now. And we're not going to fight. We're not going to fight when Jason Gichner, sorry I called him Jeff earlier, we're not going to fight his new petition. We're not going to fight it. So, there we go. And, okay, yeah. Adventure Aaron says, I would bet money that Justin wasn't deflated. Do I get a name right? Do I have his name wrong on this thing? Why am I saying his name wrong? Yeah, Jason Gichner. But I called him Jeff earlier, and we've got Justin here in the chat, but I think it's Jason Gichner. We've given him 3 different names. There we go. It's okay. It happens. And I've been having a hard friend saying Andrew Hayes for whatever reason. I have a friend with a similar name, and I'm almost saying the opposite name. So sometimes when I'm saying Andrew's full name, I'm pausing to make sure I'm saying the correct name next. But yeah, Mel says, not the son doing the investigative work. Isn't that something? Isn't that something? Law Express is quite exceptional that a member of the victim's family would go against the state's narrative. Yep. 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 Yeah. We're sorry, Jason. We'll get your name right. And yeah, good to see. I see FOTG, the source is in the building. Good to see you. Hope you're doing well. Yeah, so tomorrow we're going to look at the full new Coram Nobis petition. So I'm really excited. There's some transcripts from those recordings included. I have not looked at it yet, except I've grabbed that part. I've grabbed that part because I wanted to see exactly, between August 5th and Shelby County District Attorney Steve Mulroy, like, what exactly changed? When did these recordings come to fruition? But today we've really gone through what I would call the appeal timeline, the post-conviction timeline, the denial after denial after denial, exhausting pathway after pathway after pathway, getting shut down at every which way, every turn, to the point where if we didn't have this podcast from Stephanie Tinsley, and shout out to anyone she may have worked with, she mentions a bunch of people throughout the episodes in the podcast. I'm grouping my accolades under Stephanie because she's the one bringing everything together. And of course, the work of Jason Gichner. We wouldn't have this August 5th hearing and arguments and great effort that then inspire the son of the victim to go and build rapport with Sarah Lucas Rydell, who I guess was stupid enough to confess in a conversation to the victim's son. Whether she could have thought twice that maybe this is being recorded or not, I'm not mad at it, but it's interesting to see that somebody would just confess to a family member of the victim that they kind of just met. But happy to hear it and excited to look at it in more detail tomorrow. And Sheriff Chuck noted I gave out homework. I was giving out homework assignments. So guys, incredible podcast here. Let me go back and get to their channel for everything that they missed, for everything they missed. And just really under-listened to. And again, it goes through the details of the case, how we're getting here, why this was so wrong. This was way more emotional than the presentation I gave here today. To me, I want this to be a complimentary docket dive. I want it to go side by side with the story that Stephanie's able to tell with her podcast. So if you have not already checked it out, I have not heard somebody say a bad thing about it. So again, it's linked in the description. Just dropped it in the chat. Minus this origin story. Again, these are 26, 32, 34, 39, 29, 38 minutes. You can breeze through these 6 episodes this evening, tomorrow morning, and we'll get back together and look at that Coram Nobis petition tomorrow. It's 39 pages, which I think is great considering the emphasis on Judge Scan's opinion being 30 plus pages long. I like that those numbers kind of match up. We have closures for the Fairfax County Court. You guys may know that we've been watching the Brendan Bamfield trial. So it's confirmed that Fairfax County courts are closed tomorrow. So it's great timing to take a look at what's going on with the wrongful conviction of Andrew Hayes instead. And then maybe plan for Wednesday, we'll continue Brendan Banfield. And then quick housekeeping. I looked at who has streams coming up. I saw Defense Diaries just did an update on the Aaron Spencer case. That's already ended, so I can't redirect over there. I have us currently set to redirect over, and I'm not familiar with the case that we're redirecting over, but Take It to Trial is streaming Keith Ellis. So the family murder plot trial. She actually might have just ended her stream since I added it. Let me see. Let me double check. And if that's the case, the next up in the running, Hella Excited Utterance is going to be talking about Sarah Grace Patrick, that case and the media coverage around it. Yes, I think Take It to Trial might have ended in the last 20 minutes or so. So I'll redirect over to Hella. Let's see. But there's so much going on. Everyone's doing really great coverage of different things. And with the Sarah Grace Patrick, Hella's taking a perspective. She's doing a deep dive into like the rush of judgment, the media coverage, and reacting to the initial reporting. So I always love things like that because I always think, reactions don't always match reality. The initial reporting is always different from the reporting later on once new facts come out. There's always an imbalance, and I think it's an interesting thing and an important thing to pay attention to. Justice Served TV, I think, is going to have Nico on from the Uvalde trial. That should be starting at 6. I think that's their usual time for starting. I'm not sure if it's the other attorneys as well, but I saw Nico was in the thumbnail. So Justice Served TV has that coming up today. And then Miss Janet Demeanor, Good Janet, is having Dana McClendon. So if you guys have been following the Zach Adams stuff, Tennessee criminal defense attorney, he's going to be on with Miss Janet Demeanor tonight, and I think she usually starts at 7 p.m. Eastern. All my times are Eastern. so there's a little lineup there going for you. And then, yes, Free Zachariah Anderson. Again, I think I'm going to do like an April dive or watch into that case, at least look at some of the post-conviction relief motions. So that'll be fun. Wait, I didn't know... DB, I think I saw an X post about this. So DB says, Kat, have you seen my video trolling Jennifer Coffindoffer, who I think is part of the material Excited Utterance is going to talk about in her stream coming up soon. But she was reading a meme I made as if it was real. I think I saw an X post, but I didn't know you did. Yes, okay. Let me link to that. Everyone that's in chat will get a treat. A treat that is a tweet or an X post. Has a goodie bag on the way out. Let's see. Yeah, DB, why can't I find you on... Okay, never mind, found you. As soon as I said it out loud. Okay. DB's legendary. There we go. So there you go. Link is in the chat. If not, go check out True Crime Audit over on X. You know what? I think your YouTube name was True Crime Fraudit. So I couldn't find you because I searched for Fraudit instead of Audit. And now I've got it. So there we go. Go check out the meme that Jennifer Coffindoffer took seriously. And guys, we're going to redirect over. I don't think Hella's kicked it off yet, but you can hit the notify button and it'll bring you back around. It'll notify you when she does go live. I'll be hopping around from there, Justice Served TV, and Miss Janet Demeanor tonight. So hope to see you guys somewhere in the YouTube streets. If not, tomorrow. Probably start a little bit earlier than we started this stream. So maybe around like 10 or 11 Eastern, we'll kick off and we'll read that 38 page Coram Nobis petition that was filed just like 2 weeks ago. So excited to see what's argued there. And again, great podcast. So, I think I said I would show you. I had pulled it up, but then I switched away. But they really go in order. Like the trailer's like a minute long. We took a look at that. But they go through the start, how the crime scene, they came across this crime, they started investigated, the turn of how they started looking at Andrew Wayne Hayes, the record button, and when they choose not to record. They start talking about Sarah Lucas Rydell here. There's some crazy information. Episode 4 goes through a lot of conversations with the jurors. And this is where we jumped and played a clip from this episode earlier. Great stuff. I think it's episode 5. Stephanie brings in like 5 different scholars and or like someone that was on the receiving end of a prosecution generated through a false confession or coerced confession. And she gets all these insights from a panel of people. So, how the read technique is supposed to work, how it's misapplied, how the read technique came to be. I didn't know that the guy who came up with the read technique used to be an attorney and then became a beat cop and started working with polygraphs and false confessions. And that was the read technique origin story. Really great discussion from different scholars. She also has one of the SLED agents from that investigated Alex Murdaugh. I think it's the one that does the interviews, interrogations with Alex Murdaugh that are available on YouTube to watch. I think it's that same SLED agent. He discusses the technique and says why he doesn't really like it. He gives an example, something like, you try to give him a detail, like, oh, we know you were there because we have your fingerprints. And his reason for disliking the read technique isn't because it puts people under false pressure to confess to things that they might not actually have done. His angle on it is the way the technique works. You tell something that you don't actually know is true, or you outright lie to somebody that you're interrogating, and you say something like, we know you were there because we have these fingerprints and we tested it and it's you. And if that person is the real perpetrator, but they know in the back of their head, I wore gloves, they'll just say, no, you didn't. You don't have anything on me. So his dislike for the read technique is your lie will tell the actual perpetrator that you really don't have anything on them. Right? So it was just really interesting to listen to the different perspectives. Oh yeah, Autry says I gotta rewind. We looked at the August 2025 oral arguments. I think that was the last thing. So definitely rewind on that. Guys, I'm gonna do my walk-off music, walk myself off of here. See you tomorrow. Thank you guys for tuning in. Please show Everything They Miss and Stephanie some love. And yes, I will reach out to her when we get through this petition. And everybody tells me that they've gone and listened to all these episodes. I will reach out to her and see if she'd be willing to come speak to us. But I don't want her to have to come on and rehash all the case background. So make sure you do your homework. Check it out first. That way we can ask her like really valuable questions. And, I think she should get the reach for the work that she's doing, from my understanding, out of her own pocket. So let's show that support. And I will reach out to her and have her see if she'll come on and talk to us. But you guys all have a great evening. See you guys tomorrow or later tonight. Take care, everybody.